Yes.
Lord, with the name of Justice Kumar, may I be permitted to mention a single bench matter? Lordship is pleased to keep this matter on the 14th and led by Mr. Bachawat. He is under some personal difficulty.
If it has been directed, let it appear on that date. Just mention. Give a notice to the other side.
Well,
You the other side. When it appears, just mention.
I will. Great.
That matter. Yes.
The written notes I'm handing over.
Thank you. Yes.
And I've made sure it is smaller than the judgment.
Okay. Thank you.
Yes.
And Mr. Ghosh, you have already filed. Right. The written notes of arguments filed by the appellant be kept on record. Post up. Hearing is concluded. The matter is reserved for judgment. Thank you. Thank you very much.
As far as these documents in the note, I don't know what they are.
They have been filed in the court below, so they have been annexed here also. The
They have
written
been
notes.
filed. Handwriting,
Yes, yes.
like excerpts from Osborne.
Yes, this was all part of the written notes in the lower
Also
court.
will consider.
Lower court. It has already also been given here.
এটা ঢুকিয়ে দিয়ে ফাইল পাঠিয়ে দিন পরে চিন্তা করব যেগুলো না মার্ক আছে আমার ট্যাগ লাগানো আছে সেইগুলো পাঠিয়ে দেবো আর তুমি কোর্টে পাঠাতে পারো একবার আমি বেছে নেবো কি করা যাবে তো উপায় তো নেই ইয়েস
Item numbers 2 to 4, Lordship.
Yes.
I appear for the appellants.
Right.
Lordship, in the last order, it was directed by your Lordships
order
that
sheet দাও
the defects to be cleared, Lordship.
what were the defects
The defect was just the court fees were not filed, Lordship.
wait let us get the file first একটু পরে ফাইলটা রেডি করে রাখো সেম জিনিস হবে তা না deficit court fees or what?
Deficit court
You
fees.
have
Lordship.
deposited?
My lord, we tried to deposit. We have arranged one court fee, Lordship, out of the 3 appeals. This one court fee, Lordship, was not accepted by the department. The department stated that the order mentions defects to be cleared. They said that in the order it has to be mentioned that court fees have to be paid. And that is why they did not accept the court fees, Lordship. My lord, we are in the process of arranging 2 other court fees.
What are the other defects?
My lord, there are no other defects which the department.
অফিসে কোনো রিপোর্ট আছে এটা কোত্থেকে পেয়েছিলাম ডিফেক্ট ডিফেক্টিভটা কোত্থেকে পেয়েছিলাম অফিস কোনো রিপোর্ট দিয়েছে তা ডিফেক্টটা পেলাম কোত্থেকে আমরা
Limitation.
এখানে
Stay
মেমো পেছনে
application.
রিপোর্ট দেয় না অ্যাপেল সাইজের অ্যাপেলের মেমো পেছনে ফার্স্ট পেজের পেছনে দেওয়ার তো কথা আপনার কপিটা আছে দেখুন তো মেমো হ্যাঁ মেমো আছে So you have to deposit court fees, deficit court fees in respect of all the appeals.
My lord, one appeal, we have already prepared the court fees. The court fees are ready. They take the court fees, Lordship.
At order record.
And my lord, the other 2 court fees, Lordship, we are in the process of arranging. I'm just praying for 3 weeks to 4 weeks time, Lordship.
Right.
I'm carrying the medical certificates also.
Which one you are depositing in connection with which one? AP?
You are depositing 31 of 2024, Lordship. APDT 31.
Counsel for the appellant submits that the appellants approached the department for deposit of the deficit court fees in connection with APDT 31 of 2024, but the same was not accepted in the absence of any specific direction in the order dated January 15, 2025 to put in deficit court fees. Full stop. We direct the office to accept the deficit court fees as and when paid by the appellant in connection with APDT 31 of 2024. Full stop. Insofar as APDT 30 of 2024 and APDT 32 of 2024 are concerned, comma, the appellants are directed to put in the deficit court fees within 4 weeks from date. Full stop. As and when the same is deposited, comma, it will be accepted by the office. and a revised report shall be furnished by the office as regards whether the defects have been cured.
My lord, leave to file the stay application, lordship. Last time the leave was given. Leave to file the stay application.
Needless to say, comma, since we have already granted leave to file stay applications in connection with the appeals in the order dated January 15, 2025, comma, the appellants shall file such stay applications in each of the appeals as and when after the defects are cured.
Lordship.
Thank
you. Much obliged.
Thank you.
Much obliged.
Act line add the liberty to mention after the defects are cured.
My lord. Much obliged.
Lordship, kindly pass over this matter. Senior is stuck into traffic.
Who is your senior?
Hey,
Meghna,
no,
You don't know your senior?
he's the client. It's his matter. Meghna, I have spoken to him. Ashok, well, this matter, your lordship, we have managed to settle all.
He was asking for time on your behalf, your client's behalf.
No, not mine. Meghna is sending to me. So, well, there were two portions in this appeal. One was prayer A, B, and C at page 17 of my notice of motion, page 17 of volume 1. That was ignored. That was one grievance.
Why
That
two
has-
appeals, Mr. Ghosh?
Because there's an order, and then I filed a review of the order, and both we've come up against both.
Right.
So, recalling of the order. Well, page 17 of the volume 1 is the notice of motion, which was my original application. My lord,
Yes.
see, so prayers A, B, and C is to demarcate a portion according to the order of the Supreme Court
Yes.
and build a wall. This is Mr. Shakku Sen's client,
Yes.
and Mr. Meghnad Dotto was also appearing.
Yes.
This was in the application is for this. By the end of the order, his lordship forgot about it. Then that is one issue. We have agreed to that. Now, as far as that is concerned, there's no written terms of settlement. A letter has been written to us requesting us, when we build the wall, we must make the sewerage and the toilet and the water connections will have to be redone for them. And we have agreed to that. That your lordship may record. I'll tell your lordship.
All right.
So in fact, they wrote me a letter. I don't know why I didn't get it. So they are saying that at the time of construction of the wall, we make the following requests: that a proper sewerage system be constructed in my portion and filter water be
My
permitted.
portion is the respondent's portion.
Yes, their portion. That is, A, B, and C relate to only one party. We are walling up that portion and they are getting that.
So which is that party? Because you have to specify.
Priya Dotto, koto number?
Just give the
Defendant number 3. 3 capital A.
respondent number also is the same.
100.
Priya Dotto.
কত বলো? I'll just tell you.
Priya Dotto is
Defendant number 3.
3, yes, but it should have been 2.
3.
But it's mentioned as 3 anyway. So there's no
This
2 actually.
demarcation of the wall is as per the order of the Supreme Court, and that is the receiver is to be directed to carry that out. There's no issue on that.
Very well. Very
As far as the 7A and B, prayer D onwards is concerned,
yes.
we have signed the terms of settlement and a joint affidavit. But there's one affidavit, one copy. I'm sorry, because one original affidavit. Your lordship will see this. In terms of this, the rest of the application may be disposed of. So we have agreed to. They have agreed to move out. Then we will build this wall, and then
We will make the terms of settlement a part of the of our order.
yes, and
Insofar as CD and E are concerned.
my lord. I'll just check. No, E is no longer required. Alternatively,
Right.
so also D, we had said that you take compensation. So it's those prayers have been settled. Not in terms of the settlement, it is disposed of. That we are giving them.
So no, we'll dispose of CD and regarding CD and E, we'll dispose of your challenge in terms of the terms of settlement. We'll record, Mr. Ghosh, that
Yes,
A and B, as you said,
yes.
the parties have agreed to this, to the prayers, subject to sewerage and water supply
supply.
being kept, arrangements for that being made separately for respondent number 3, Priya Datta. And regarding C, D, and E, we dispose of the appeal in terms of these terms of settlement. Right. Only that.
Only to remind my lord that they were to come get in the new building in the neighboring portion. They refused.
Yes.
So that portion got filled. Now they will get in the new, the
In
one
a-
that we will construct, that we are giving.
That has been agreed.
Yes, we know.
Yes. Not difficult.
No, he's saying that will they build after we have left the premises? I said, I'm sure that. Shifting
One
for
indulgence, my lord,
residential, I
Mrs. Sen is leading,
Yes. What is the indulgence?
3, my lord. My lord, she's on legs, my lord.
Let him bullet this. That letter can be
My lord,
given.
later has been
This is a
given-
letter that I read out.
Keep it on record.
I don't know why it was sent to me, but we,
Huh.
we are agreeable. That's I asked the client. He has said we are agreeable. It's only a request they made, and we are agreeable.
But you are agreed. So this bath privy with proper sewerage, all of these.
Bath privy, I said we'll give the connection. So because I asked Mr. Dotto, does he want particular Jaguar fittings? He said no, only the. They've understood that, but it's only a request. They said they have absolutely no.
There are three things here in the letter. One is bath and privy with,
Yes.
you have to construct a bath and privy with proper sewerage.
Mm.
So you are
We-
giving
we
only
are
the
saying
sewerage.
Sewerage and water connections, we will ensure that they get that.
Very well. Your client is present in court. You should have taken instruction. This is the
No,
second
he
matter.
came to me personally. Priya Datta's son, he's an
My lord,
advocate.
I request him to come, my lord.
But
Request him to come after the matter is over.
And the third thing is due care and caution. I hope my client will take it, that they will not destroy the existing portion. That is there. We have agreed to that.
Well, a filter water tap? No.
The filter water, he's explained it. It comes through their portion to mine. So arrangements have to be made. So it's bifurcated or whatever.
Well,
But,
so heard learned senior counsel appearing for the appellant.
intervener appellant. Well, I'm not a party.
That's very well. Heard learned counsel, senior counsel appearing for the intervener. First up, the affidavit filed today, containing the terms of settlement between the parties in respect of prayers C, D, E, and F in the notice of motion before the court below are kept on record. First up, next para. In terms of the submissions of the parties, we dispose of both the appeals.
Yes.
We dispose of both the appeals and number then APO 110 of 2024 and such, in terms of the following directions: (D, small a, the reliefs as sought in prayers small a, small b, and small c in the notice of motion before the court below, which are set out below, are hereby granted, subject to the appellant providing separate sewerage and water connection for the respondent number 3, Priya Datta. Full stop. Next para. Insofar as reliefs small d, small e, and small f are concerned, in view of the agreement arrived at between the parties, as reflected in the terms of settlement filed today, the appeals are disposed of in terms of the clauses of the said terms of settlement, which are made a part of the present order. Full stop. Needless to say, the appellant shall exercise due care and caution at the time of demolition of the building in terms of the settlement between the parties, falling in the portion of the developer, so that the portion of respondent number 3, Priya Datta, of the building is not affected or damaged in any manner. Push up, there will be no orders to costs. Yes.
Well, one
Lord.
prayer A and B in case the learned receiver, they always have the liberty, but I was asked that in case required, police help could be taken. It will be done under the aegis of the learned receiver. So if he so feels,
In terms, the terms of settlement say it will be done.
no, that is not between 7A and B. It's not the thing. It is only to when constructing the wall, etc. They are apprehending if there is
Okay.
anything.
The
local
above
problem.
demolition and construction work shall be done under the aegis of the receiver already appointed by court. Full stop. It will be open to the learned receiver to approach the concerned police station, the local police station, for adequate police assistance in the event of any obstruction from any quarter. Full stop. If so approached, comma, the officer in charge, stroke inspector in charge of the said police station shall grant adequate assistance to the learned receiver for the said purpose by acting on a server copy of this order, comma, coupled with the written communication by the learned advocate for either of the parties.
Grateful.
আচ্ছা একটা জিনিস যেখানটা বলেছি as set out below বলেছি প্রথমে ওখানে পেজ 17 এ GA, what is the GA number? GA1 of 2024 filed in connection with APOT 125 of 2024 is also disposed of in the light of the above observations.
But insofar as the separate sewerage your lordship has provided,
Yes.
the respondent number 3's portion, that will be supervised by the receiver only,
That
but
is-
whoever will
The
do it.
receiver is supervising the construction.
We have
of
said
the-
in general terms that the entire demolition and construction work will be supervised by the receiver.
And regarding the
Storage also falls within construction.
Won't take that time.
My lord, I appear for the respondent number 1.
When my lord, I'm appealing for the appellate.
Role reversal today.
My lord,
Pardon?
I appear
Role reversal today.
Role reversal. Right?
My lord,
Only one thing, my lord, before my learned senior friend commences his arguments, my lord. My lord, there's one small typographical error, my lord, in the order of lordships. My lord,
Which
of
date?
5th February, my lord.
Yes, what is that?
My lord, what has happened if lordship sees the cause title? In fact, the appellant's learned advocate's name has gone down. She has become a litigant. Lordship sees Pradeep Kumar Ganeriwala and another Anjana Banerjee. So, my lord, possibly, my lord, that Anjana Banerjee needs to be deleted. my lord.
Absolutely.
My lord, I have otherwise no issue, my lord. She becomes a litigant.
We start with that. It is rightly pointed out by learned counsel appearing for the respondents that in the cause title of the order dated February 5, 2025, comma, after the expression double inverted Pradeep Kumar Ganeriwala and another double inverted close, comma, the name of the learned advocate for the appellant has erroneously been transcribed. Full stop. Let the name of the said learned advocate be deemed to stand deleted from the cause title of the said order.
my lord, I am appearing for
এটা প্রথমে থাকবে তারপরে যা অর্ডার হবে
respondent number 2,
রাইট
applicant in GA number 2
অলরাইট
in the appeal.
হোয়াট ইজ দ্য অ্যাপ্লিকেশন ফর
No, status suited.
মিস্টার মাল হোয়াট ইজ দ্য অ্যাপ্লিকেশন
My lord, application is for deleting the name of the respondent Bharat Petroleum from the area of parties. My lord, application is.
Since we are taking up the appeal, we'll decide that. I mean, if you have any role to play, why
No,
delete
my
your
lord,
name at this stage?
This application was filed pursuant to a leave granted or observation granted by the erstwhile division
Take
bench
up the application
on
along with the
20th
appeal.
November.
If you feel after hearing the appeal that they are not necessary parties, then we can pass that direction also. But at this stage, it's ripe for hearing, so let us take up the hearing. It depends on the hearing also. If you feel that no, they are a necessary party, because otherwise for that application, we'll have to hear the merits of the appeal also. Tangentially, it has to be touched.
As your lordship pleases, in the manner or whatever.
Yes, yes, Mr.
Because
Mitchell.
there is also an observation of the Supreme Court. They approached the Supreme Court against that observation of the
That leave was given to you.
leave was given to us. We filed. They went up to Supreme Court. Supreme Court said they should be
Remains.
heard. They should be heard if an application is filed.
We'll hear you.
He should be heard if I file an application for deletion.
We'll hear all.
Yes, yes. Certainly.
Yes, Mr. Mitch.
My lord, the order impugned is an order dismissing an application under Section 8 of the, my lord, Arbitration and Conciliation Act. On the ground, I
Yes.
shall place the order
Yes.
on the ground that apart from the parties to the arbitration agreement, there are other parties, namely the defendants number 325.
All right.
Now, my lord, kindly take up the plaint once.
Because 3 to 5 were obviously not parties to the arbitration agreement.
There is no dispute.
You say that the primary relief is not sought against them.
They have been added, my lord, to avoid the arbitration. And my lord,
Acha.
kindly look into the framing of the plaint in my respectful submission. They are not necessary parties, my lord. No relief also can be claimed against, my lord, some of them.
We'll look into the plaint then.
Kindly come to page 39. Yes, sir, please. 39.
39. 39, yes. Yes, Mr. Mitch.
May I, my lord? It's a short plaint. May I read it?
Yes, yes, absolutely. Why not?
The plaintiff, sometimes around March, April 2022, was one of the partners of defendant number 1 having its office at such and such. Defendant number 1 is a partnership firm dealing with petroleum products, commonly referred to dealer, etc. Defendant number 1 has tremendous goodwill and has been making huge profit every year. Till March 2022, the plaintiff and the defendant number 2 were the only partners of the defendant number 1. The plaintiff and the defendant number 2 are brothers. The defendant number 2 is the continuing partner of the defendant number 1. The defendant number 3 is the son of Dilip Kumar Ganeriwala and nephew of the plaintiffs. These names may come back, my lord, to your lordship's mind.
Yes,
Yesterday
yes.
only, my lord, these names were
Yes.
taken
Yes, right.
between the same parties. The defendant number 4 is the son of Rajiv Kumar Ganeriwala and nephew of the plaintiff. Plaintiff Dilip Kumar Ganeriwala. The plaintiff Dilip Kumar Ganeriwala, Rajiv Ganeriwala, and the defendant number 2 are brothers. Presently, the defendants number 2 to 4 are the partners of the defendant number 1, and they carry on business in partnership from 3 India Exchange Place within the jurisdiction. Defendant number 5 is a company. It's not required. Kindly come to paragraph 6. It supplies petrol, defendant number 5. Kindly come to paragraph 5. Sorry, kindly come to paragraph 5. The plaintiff and the defendant number 2 had equal share in the defendant number 1 firm prior to the plaintiff retiring from the defendant number 1. The plaintiff and the defendant number 2 started and or continued with the defendant number 1 firm as his partners by and under a deed of partnership dated 23rd August 1994. A copy of the partnership is annexed here too. Original deed of partnership is in the custody. Now kindly come once to page 61, the deed. Copy of the deed.
That deed contains the arbitration clause also.
It's between the plaintiff and the defendant number 2 as stated by them. And kindly come to page 65. Page
Yes.
65 at the top, clause 12.
Right, right.
That in case of any dispute arising between the partners or their legal representatives, the same shall be referred to the decision of so-and-so, under whose jurisdiction the retail outlet is situated, for arbitration either by him or his nominee. Decision of the arbitrator shall be conclusive and binding on the partners. Now kindly come back to page 41, well, page 42.
Yes.
Paragraph 6.
Right.
Inasmuch as the defendant number 1 deals with petroleum products within the jurisdiction aforesaid, the defendant number 1 is mandatorily required to obtain motor speed, high-speed diesel oil selling license from the Department of Food and Supplies, Director of Consumer Goods, Government of West Bengal. Defendant number 1, or for that matter, any dealer or retail outlet dealing with petroleum or petroleum products in the state of West Bengal cannot operate and/or function and/or sell petroleum product from their respective retail outlet in absence of such license. Sometimes in the year 2017-18, certain disputes and differences arose between the plaintiff and the defendant number 2 with regard to the working and/or functioning of the defendant number 1 firm within the jurisdiction aforesaid. The defendant number 2 then asked the plaintiff not to involve himself in the working and/or functioning of the defendant number 1 and assured the plaintiff that he will get his due share of profit out of the working of the defendant number 1 after conclusion of every financial year. In order to buy peace, the plaintiff chose not to get into any kind of confrontation with the defendant number 2 and chose not to involve himself in the working and/or functioning of the defendant number 1 as suggested by the defendant number 2. The plaintiff bona fide and in good faith without asking any question accepted that. Then defendant number 5 in the meantime, sometimes in or about 2020 asked the defendant number 1 to enter into a fresh agreement for continuation of dealership with the defendant number 5. The format of such agreement was prepared by the defendant number 5 and forwarded to the defendant number 1 for its execution. The plaintiff, defendant number 1, defendant number 2, and defendant number 5 accordingly entered into a fresh agreement. That's my lord, the dealership agreement, not the partnership. Then 9. The plaintiff in the meantime, not being happy with the way and manner in which the defendant number 2 was operating and/or conducting the affairs of the defendant number 1, sometimes in the year 2021 expressed his desire to sever all ties with the defendant number 1 and to retire from the defendant number 1 and sought return of his capital in the defendant number 1, his share in profit of the defendant number 1 as on the date of his retirement, and also his share in the goodwill of the defendant number 1. So, well, this demand had to be to the defendant number 2, 3 and 4 when were there. The defendant number 2 then proposed to the plaintiff that inasmuch as the defendant number 1 was a retail outlet and or dealer of the defendant number 5, and they were governed by the rules and or guidelines framed and or issued from time to time by the defendant number 5, it would not be advisable to dissolve or reconstitute the defendant number 1 without first speaking with the defendant number 5. The defendant number 2 thereafter approached the defendant number 5 outside the jurisdiction aforesaid, whereafter the defendant number 2 impressed upon the plaintiff to agree to retire from the defendant number 1, citing his ill health and old age, and suggested that the names of the defendants number 3 and 4 as new incoming partners of the defendant number 1. The defendant number 2 assured the plaintiff that the dues of the plaintiff, including payment of goodwill of the defendant number 1, in accordance with the plaintiff's share in the defendant number 1, shall be paid by the defendant number 1 to the plaintiff shortly after approval of sanction of reconstitution of the defendant number 1 by the defendant number 5 and reconstitution of the defendant number 1. The plaintiff, having no further desire to continue as a partner of the defendant number 1, asked the defendant number 2 to take whatever steps were required to be taken for the purpose of the plaintiff's retirement from the defendant number 1, and that the defendant number 2 was at liberty to choose whomsoever he intended to introduce as partners in the defendant number 1. But at the same time, clear all dues and outstandings of the plaintiff, including his share in the goodwill and in the defendant number 1, goodwill of and in the defendant number 1, and ensure removal and or deletion of the name of the plaintiff from all records, departments, authorities, entities, etc. as a partner of the defendant number. The plaintiff and the defendants number 1 and 2 also discussed, and the plaintiff estimated the goodwill of the defendant number 1 to be rupees 2 crore and told the defendant number 2 that according to the share of the plaintiff, the defendant number 1 firm, the plaintiff was entitled to get rupees 1 crore on account of the goodwill of the defendant number 1. The defendant number 2 was non-committal on the quantum of goodwill estimated by the plaintiff, but assured the plaintiff that the plaintiff will be given his legitimate and due share towards the goodwill of the defendant number 1 as on the date of retirement of the plaintiff from the defendant number 1. The defendant number 2 thereafter told the plaintiff that in order to arrive at and ascertain the quantum of goodwill of the defendant number 1, he would consult a chartered accountant, etc. Then paragraph 10. The defendant number 2 had also proposed the name of the defendants number 3 and 4 as incoming partners of the defendant number 1 in place of the plaintiff and caused one proposed deed of retirement to be prepared in accordance with the format provided by the defendant number 5. Since the format of the agreement was prepared by the defendant number 5, the plaintiff had no say in the same and he simply signed on the dotted lines. The draft of the proposed retirement deed was then sent to the defendant number 5, who sometimes in or about March 2022 approved the changes in constitution of the defendant number 1. The constitution of the defendant number 1 as such stood changed on and from 1st April 2022, with the plaintiff no longer being its partner and the defendants number 2 to 4 as partners of the defendant number 1, each having equal share therein. The plaintiff ever since then has been patiently waiting for the defendants number 1 to 4 to pay and clear his dues. In view of the plaintiff having retired from the defendant number 1, it was obligatory on the part of the defendants number 1 to 4 to take immediate steps for removal and or deleting the name of the plaintiff as one of the partners of the defendant number 1 from the records of all the authorities, departments, bodies, etc. The plaintiff had also asked the defendant number 1 and 2 to take all steps to ensure that the retirement of the plaintiff from the defendant number 1 is recorded in all government departments and or authorities and or bodies and or records, and his name as partner of the defendant number 1 is removed and or deleted from the records of all departments. The plaintiff consented to sign documents to complete recording of his retirement from the defendant number 1 and or for reconstitution of the defendant number 1 and or removal and deletion of his name as partner of the defendant number 1 before all authorities and or bodies without waiting for the defendant number 1 to 4 to clear the dues of the plaintiff, including payment towards goodwill. The plaintiff bona fide and in good faith accordingly signed numerous documents and or forms and or communications and or undertakings as were placed by the defendants number 1 and 2 before the plaintiff. The defendants number 1 to 4 were obliged immediately to ensure that the name of the plaintiff was removed and or deleted from the records of all authorities and or bodies wherever his name was reflected as one of the partners of the defendant number 1, more particularly in the records of the Government of West Bengal, Department of Food and Supplies, which issues license, etc. The defendants number 1 to 4 were obliged to take immediate steps for removal and or deletion of the name of the plaintiff as a partner of the defendant number 1, but the defendants number 1 to 4, with a malafide and ulterior motive, had not taken any step. Then, my lord, kindly skip a few lines. My lord, the plaintiff has since realized that the defendant number 2 only had intention of removing the name of the plaintiff from the defendant number 1 and depriving the plaintiff of his entitlement and share in the goodwill of the defendant number 1, and in the process induce the plaintiff to sign the proposed deed of dissolution, retirement, and various communications. The plaintiff, having realized the wrongful fraudulent intention of the defendant number 1 by email dated such and such, brought it to the notice of the defendant number 5 about the wrongful and illegal activities of selling licensed commodities, etc. Then paragraph 13 kindly come to. Then, my lord, sorry, he had handed over the documents to the authorities also. Paragraph 13, the defendant number 5, then by its email issued from outside jurisdiction, informed the plaintiff that it had taken up the matter of non-arbitration of retail selling license with the dealer and also as the plaintiff to follow up with the concerned authority, however, took no steps itself to takes no steps in the matter. The plaintiff respondent then, my lord, kindly come to paragraph 17. Page 48. The plaintiff, patiently having waited for the defendants to undo their wrongful and illegal act, thereafter by its letter dated 22nd June 2023, called upon the defendant number 5 with copy marked to defendant number 1 to 4 to immediately stop supply of licensed essential commodities to the defendant number 1, which were being sold in an illegal and wrongful manner on the strength of an expired license which continued to carry the name of the plaintiff. The defendant number 5 duly received such letter but still chose not to act in terms of such communication. The aforesaid goes to show that the defendants have joined hands together and are acting to the detriment of the interest of the plaintiff and to cause great prejudice to the plaintiff. The products in which the defendants are dealing are licensed essential commodities and can be sold and are stored strictly in accordance with the license granted, and the persons named in the license are always personally liable and are responsible for any act and or wrongful doing of the defendant number 1 to 4 in any working and or functioning of the defendant number 1 and or for any action of any authority and or department and or entity against the defendant number 1. The plaintiff, having expressed his intention to retire on the basis of which the defendant number 1 has been reconstituted without the plaintiff being its partner, but the plaintiff's name continues to be reflected as partner of the defendant number 1 in the records of various government authorities. The defendants number 1 to 4 have also failed and neglected to pay and clear their dues of the plaintiff, including plaintiff's entitlement towards the goodwill of the defendant number 1. Then paragraph 20, in the facts and circumstances aforesaid, the plaintiff suffered and continues to suffer irreparable loss. Then declaration, perpetual injunction. This is the.
Now let us see the reliefs also, sir.
Yes. Kindly come to my lord, page 53.
Yes.
A decree for declaration declaring that the plaintiff is not a partner of the defendant number 1 on and from 1st April 2022. Nobody is saying. B. Perpetual injunction restraining the defendants number 1 to 4 from in any way, manner dealing with and or selling any petroleum and or MSHSD product in the name of the defendant number 1 from such and such, till the time the name of the plaintiff is removed and or deleted from the records of all departments, statutory authorities and or bodies and or institutions as a partner of the defendant number 1. Perpetual injunction restraining the defendant number 5 from supplying for resale petroleum products and licensed essential commodities to the defendant number 1 till the name of the plaintiff is removed and or deleted from each and every department and or authorities and or body and or establishment where the name of the plaintiff appears as the partner of the defendant number. Mandatory injunction directing the defendants number 1 to 4 or any of them to file and or furnish documents and or undertakings before the honorable court evidencing and or declaring removal and or deletion of the name of the plaintiff as a partner of the defendant number 1 from the records of all departments. Decree for a sum of rupees such and such, interest, again decree for such and such. Number 2 submissions. So far as, my lord, the monetary claim is concerned, or, my lord, any claim after the dissolution, admitted dissolution, my lord, has to be against the defendant number 2. There was no contractual obligation or contractual, my lord, involvement between the plaintiff and the defendants number 3 and 4. I shall come to 5 later on. They had nothing to do.
But you have asked for the relief against the firm, partnership firm, of which 3 and 4 are now partners.
today, my lord, kindly consider this situation. Today, the defendant number 3 and 4 are the partners, but the claim of the plaintiff was on a date when they were not a partners.
But if a relief has to be granted in the suit, Mr. Mitro, then 3 and 4 as partners of 1 will automatically be affected.
If they had taken over the liability, yes.
The firm, your relief is in the firm of which they are now partners.
Yes.
So it's joint and several liability.
It is, my lord, the liability of the then partner, my lord. It cannot be, my lord, a liability of a person who has been subsequently implemented or subsequently joined as a partner.
But then you have to reframe C.
Kindly consider a situation.
You have to reframe C then.
I shall come to.
Yes, please.
Kindly come to a situation. A partnership of 2 persons. One goes out. It continues to be the liability of the other one. Unless the new partners will undertake to discharge that liability.
You are defendant number 2.
It's a joint application.
By all the different up to 4. 1 to 4.
Yes.
All right.
Yes. They cannot have any liability. I'm not going into because they have not relied on the deed of my lord retirement. That says, my lord, he will have no claim. All these cases, my lord, those are, my lord, on merit.
On merit, yes.
But as on date, so far as, my lord, in my respectful submission, so far as 2 and 3 are concerned, my lord, he has no cause of action.
3 and 4.
Against 3 and 4. The plaint does not disclose any cause of action. I could have understood, my lord, that the case was, my lord, that the 3 and 4 undertook to pay. That was not done. That is not the case. This is one. So far as, my lord, the other obligations are concerned, my lord, the name of, my lord, the plaintiff being struck off, my lord, he has, my lord, that is his separate cause of action. Causes of actions have been joined here. Cause of action against the defendant number 5, if at all, any. It's a completely different cause of action.
But aren't they related because they have sought an injunction? It's a reciprocity of the injunction sought against the defendant numbers 1 to 4, because the defendant numbers 1 to 4 shall not operate, and 5 will also not. 5 is also to be injuncted from permitting them to do so.
Can you do that? If I may ask myself the question.
But then it will be an incomplete relief for them if 5 is not restrained. It will be an incomplete relief if 5 is not restrained.
After having retired, can he do that? My lord, his remedy lies elsewhere. He can, my lord, approach the government department, say that, yes, I have retired, delete my name.
But we have to go by the suit as framed, Mr. Mitra. For section.
That is exactly what, my lord, the courts are saying, that look into the plaint, whether, my lord, an attempt has been made to avoid the arbitration. Now, my lord, today before your lordships, my lord, even the 3 and 4 have said that send it to arbitration. They are also agreeable to go to arbitration. Only dispute is about 5. The application is a joint application. I could have understood, my lord, that the application was by 1 and 2. They are saying that, my lord, there is an arbitration agreement. No. 3 and 4 have also joined. So, my lord, the recent Supreme Court judgments also say that even non-parties can be added.
And also you have a point there, because the language of the partnership deed is quite wide. In case of any dispute arising between the partners, not fixing it to the partners on that day. It may be, it's a subject matter of interpretation, maybe by the arbitrator if referred. And change of constitution with prior approval of BPCL has also been taken care of in clause 14. So there can be a reconstitution, and read with clause 12, the arbitration clause, which says partners or the legal representatives, dispute between them. So they are now partners. So broadly, we may construe that Yes, for the purpose of section 8 at least, 3 and 4 are also within the definition of these partners at a subsequent point also. But relief against 5 is
Yes, relief
there.
against 5 is a completely different relief.
Why do you say that? Doesn't it arise from the same string of cause of actions?
But in my respectful submission, no.
Hmm.
Kindly come to my lord, the relief against 5.
Yes.
Perpetual injunction restraining the defendant number 5 from supplying for resale petroleum products and or licensed essential commodities to the defendant number 1 till the time the name of the plaintiff is removed.
Yes.
And or deleted from each and every department and or authority and or body and or establishment where the name of the plaintiff appears as partner of the defendant number 1. Now, this is a cause of action in my respectful submission, if at all any, is solely against the defendant number 5. It's a completely different cause of action. Today, my lord, the firm has been reconstituted. They say that the firm has been reconstituted with the consent of BPCL. So, in the records of BPCL, my lord, the defendants number 2 to 4 are the partners of the defendant number 1 and none else. So, this is an independent cause of action in my experience. It has got nothing to do with, my lord, the other cause of action of the plaintiff, like getting the money.
But if plaintiff has a cause of action, Mr. Mitro, in respect of his continuance as a partner, being reflected as a partner in all the documents, and BPCL approved that reconstitution.
Yes.
And is continuing to supply whatever.
Yes.
Now
continuing to supply to a partnership of 2 to 4.
Yes. Yes. 2 to 4.
Yes.
Which isn't that related to the other relief that his name should be deleted? Because that deletion, if that deletion occurs, the approval was granted by BPCL in respect of that. In the records of the BPCL also the name has to be deleted.
It has been. It's not their case that in the kindly.
Yes.
Kindly come to.
Yes.
ওই প্যারাগ্রাফটা বলো যেখানে হ্যাঁ না বলেছে যে রিকনস্টিটিউট আছে Yes, kindly come to page 45, Malak.
Yes. So you say that is there. The constitution has been changed.
It has been.
And that has been approved.
That has been done. After that, he cannot say don't supply.
All right.
Now, my lord, in my submission, question is whether, my lord, 2 independent causes of action have been sought to be joined here in this plaint to avoid the arbitration agreement.
What is the cause of action against BPCL? The independent cause of action?
To submission, none.
You may also argue probably that C is a fictitious cause of action.
Yes.
I mean, just to bring it within the purview of. You may argue that because.
Yes. According to me, none.
If it was not to supply till plaintiff's name is removed from the BPCL records, it's not that.
No.
Every department, every authority, and all these things. I mean, BPCL
and BPCL
as Mr. Mal must submit that. Why should BPCL be bothered even?
Yes. BPCL cannot do anything so far as the other departments are concerned.
Yes.
BPCL has reconstituted his record.
All right.
Deleted his name, has taken into the names of the other 2 defendants.
All right. How did the learned trial judge proceed with it?
Yes, my lord, kindly come to the order impugned. Kindly come to page. Oh, page 193, or my lord, the memo, my lord.
Memo will become easier. You can refer to the internal pages, Mr.
My lord, page 8.
Yes.
Section 8 of the Arbitration and Conciliation Act deals with the power of the judicial authority to refer the parties to arbitration. The core of the provision is that if there is a valid arbitration agreement existing between the parties and a dispute arises which is a subject matter included in the said arbitration agreement, then the judicial authority before whom either of the parties has brought the case is obligated under Section 8 of the Arbitration and Conciliation
Act. Sorry, Mr.
page 8. Then the judicial authority before whom either of the parties has brought the case is obligated under Section 8 of the Arbitration and Conciliation Act to direct the parties to resolve their disputes through arbitration. This section minimizes judicial intervention by making it mandatory for the court to direct the parties to go for arbitration if they have included an arbitration clause in their agreement. To further increase the scope of arbitration, the 2015 amendment to Section 8 of the said Act made it compulsory for the judicial authority to refer the parties to arbitration irrespective of any decree or court order or judgment of any court. May I hand over, my lord, for the...
No, we have got a copy. Another copy we'll get. Right now, we need not look into it. I mean, it's quoted also, Mr. Mithis, it's quoted
Sir,
here.
yes, it is.
It is quoted. So,
No, I thought, my lord, for...
we are not looking into that provision right now. If necessary, we'll take.
The Section 8 of the Arbitration and Conciliation reads as follows. I'm skipping that, my lord.
Yes, yes,
Kindly
obviously.
come to paragraph 18. Upon combined reading of the whole claim, it reveals that the plaintiff has categorically made claim against the defendants number 3, 4, and 5 also. After induction of the defendants number 3 and 4 as partners of the defendant number 1 with the defendant number 2, even after the defendants are using the name of the plaintiff, and to that effect, this court by an order dated 18 September 2020.
বসুন আপনারা বসুন আনি নিন
This court by an order dated 18 September 2023, 4th October 2023 and 4th December 2023 has passed several directions for removal of the name of the plaintiff from licenses. This court finds that the plaintiff has made the defendants number 3 to 5 as party to the suit, and specific case has been made out against the defendants number 3 to 5 that they have not taken any step for removal of the name of the plaintiff from the records of the defendant number 1, and also not paid the amount of the amount to the plaintiff, which the plaintiff is entitled to get after retirement as partner of the defendant number 1. And admittedly, the defendants number 3 to 5 are not parties to the partnership deed entered between the plaintiff and the defendant number 2. And thus, clause 12 of the Partnership Act is not applicable against the defendants number 3 to 5. Case made out by the defendants that the plaintiff has set up illusory cause of action against the defendants number 3 to 5 is not sustainable.
Yes. All the appellants were applicants in the section 8.
All the applicants were applicant in section. And now, my lord, if your lordship is pleased to take up the application which has been filed by, it's for them to move, my lord, I am not here to. But they say that they have taken all steps. Or they took all steps.
We'll hear Mr. Mal before you,
Yes, ma'am.
so that you can give. Right.
Now, my lord, like to rely on, my lord, three judgments, my lord.
Absolutely, please.
My lord, the first one is reported in 2022 SCC Online Calcutta page 170. It's a single bench judgment, my lord, but discussions are elaborate.
Yes.
Kindly come to the first two paragraphs. The issue in these applications for reference of the dispute to arbitration is whether the dictum of Supreme Court in Shukanna, non-permissibility of bifurcation of subject matter or cause of action in the suit should be considered by a court in an application under Section 8 of the Arbitration and Conciliation Act as amended in 2016. The applicant have filed two applications for reference of claims, disputes, and differences made by the first plaintiff against the applicants to arbitration. The applicants are defendants number 41 and 42 in the suit filed by Lindsay and its majority shareholders and directors. Now, kindly come to paragraph 6. The learned senior counsel appearing for the applicant IFGL argues that the arbitration clause has not been, paragraph
Opposes
6. I'm sorry, man. Learned senior counsel appearing for the plaintiffs opposes the reference on the ground that the disputes against the different defendants are inextricably interlinked and are incapable of piecemeal adjudication. Counsel submits that the reliefs prayed for by IFGL are geared to bifurcate composite causes of action and split necessary and proper parties. It is submitted that the disputes forming the subject matter of the suit are not covered by the arbitration agreement and do not arise out of the limited scope of purchase orders to which the arbitration agreement relates. Counsel relies on Shukanna. Then, my lord, kindly come to, it goes on upon consideration of the submissions made on behalf of the parties. Then, my lord, the legislative intent. Then paragraph 9, it goes on, kindly come to, my lord, paragraph 24.
Yes.
It is thus evident from the statements made in the plaint that the suit has been filed against two groups of defendants with separate claims and causes of action, which has been claimed and pleaded against each of the said groups, more specifically Mittal group consisting of so-and-so, to whom the plaintiff number 1 was selling goods, and to the vendor group from whom the plaintiff company was buying goods. 25. Order 2, Rule 6 of the Civil Procedure Code 1908 gives an option to the court to order separate trials where there are joinder of causes of action in one suit, which has a potential of delaying the trial or otherwise cause inconvenience to the proceeding. The aforesaid provision hence provides for cases where bifurcation and separate trials are called for by reason of joinder of cause of action and parties. As discussed in the preceding section of this judgment, the reliefs claimed against the two groups of defendants, namely Mittal group and vendor group, are separate and independent of each other. The disputes or reliefs as claimed in the suit are hence bifurcable. It is also to be noted that the suit was filed after receipt of notice under such and such for commencement of arbitration. Then kindly come to 27. It can fairly be assumed that the plaint has been prepared with the object of avoiding the arbitration agreement between the plaintiff number 1 and the vendor group of defendants. In NN Global, the Supreme Court held that all civil and commercial disputes, either contractual or non-contractual, which can be adjudicated by a civil court in principle, can be adjudicated and resolved through arbitration unless it is excluded, either expressly by a statutory or by necessary a necessary implication. The Supreme Court further proceeded to hold that the 1996 Act does not exclude any category of disputes as being non-arbitrable. The Supreme Court reiterated the categories recognized in Booz Allen as instances of disputes which are not arbitrable. In that case, the Supreme Court held that the civil aspect of fraud can be adjudicated by an arbitral tribunal, with the only exception being where the arbitration agreement itself is vitiated by fraud or fraudulent inducement and goes to the validity of underlying contract and impeaches the arbitration clause itself.
These are not applicable here because there is no dispute regarding the arbitrability per se.
Absolutely. And my lord, 29, hence this court does not
Yes.
find any merit in the argument made on behalf of the plaintiffs. Now, my lord, here, my lord, it dealt with, my lord, joinder of causes of action, as I have already submitted before your lordship. A part of cause of action as claimed against the defendants number 1 and 2 has got nothing to do with the claim against the defendant number 5. The plaintiff has or cannot have or has not said about any cause of action against 3 and 4. There was no, my lord, privity of contract between the plaintiff and the defendants number 3 and 4. That is not the case of the plaintiff. So far as the relief claimed against the defendant number 5 is concerned, my lord, that can be claimed legally. I am not a necessary party in that claim. Now, my lord, the next, my lord, I would like to type it here. My lord, 2024 SCC Online Supreme Court 2597. SCC Online Supreme Court 2597. Yes, paragraph 69 and 70. Kindly give me a minute, sir. Yeah, but it could get look at. Kindly come to paragraph 69.
Yes.
The fact that a non-signatory did not put pen to paper may be an indicator of its intention to not assume any right, responsibility, or obligation under the arbitration agreement. However, the courts and tribunals should not adopt a conservative approach to exclude all persons or entities who intended to be bound by the underlying contract containing the arbitration agreement through their conduct and their relationship with the signatory parties. The mutual intent of the parties, relationship of a non-signatory with a signatory, commonality of the subject matter, composite nature of the transactions, and performance of the contract are all factors that signify the intention of non-signatory to be bound by the arbitration agreement. An important factor to be considered by the courts and tribunals in the participation of the non-signatory in the performance of the underlying contract. In this regard, it was observed in Cox and Kings. Well, this is 2024 4 SCC 1. The intention of the parties to be bound by an arbitration agreement can be gauged from the circumstances that surround the participation of the non-signatory party in the negotiation, performance, and termination of the underlying contract containing such agreement. So, and so principle of international commercial contract, principle of international provides that the subjective intention of the parties could be ascertained by having regard to the following circumstances: preliminary negotiation between the parties, practices which the parties have established between themselves, conduct of the parties subsequent to the conclusion of the contract, the nature and purpose of the contract, meaning and commonality. Evaluating the involvement of the non-signatory parties in the negotiation, performance, or termination of a contract is an important factor for a number of reasons. First, for being actively involved in the performance of a contract, a non-signatory may create an appearance that it is a veritable party to the contract containing the arbitration agreement. Second, the conduct of the non-signatory may be in harmony with the conduct of the other members of the group, leading the other party to legitimately believe that the non-signatory was a veritable party to the contract. And third, the other party has legitimate reasons to rely on the appearance created by the non-signatory party so as to bind it to arbitration. Well, it goes on, Miller, to set out the... Then kindly look into paragraph 71. It is evident that the intention of the parties to be bound by an arbitration agreement can be gauged from the circumstances that surround the participation of the non-signatory party in the negotiation, performance, and termination of the underlying contract containing such an agreement. Further, when the conduct of the non-signatory is in harmony with the conduct of the others, it might lead to the other party or parties to legitimately believe that the non-signatory was a veritable party to the contract containing the arbitration agreement. However, in order to infer consent of the non-signatory party, their involvement in the negotiation or performance of the contract must be positive, direct, and substantial, and not be merely incidental. Here, my lord, by making the application, they have, my lord, expressed their intention to be bound by the arbitration. My lord, those are my respectful submission. As I said, my lord, that claim against defendant number 5, the cause of action against defendant number 5 is completely separate. It has got nothing to do with the rest. And my lord, the rest can be referred to arbitration.
Thank you. So we'll hear Mr. Mal first then.
I'll restrict my submission to the prayers made in my application, whether I am still a proper and necessary party in the suit. My lord, that was the observation of also the erstwhile division bench, my lord, from which they went up to appeal before the Honorable Supreme Court, and Supreme Court has directed all parties to be heard. Now, my lord, Lordship has seen, my lord, most of the facts have been stated by Mr. Mitro. My lord, only page, the plaint at page 54. My lord, only relief against me.
Yes. You want the deletion of your name from this appeal?
From the suit.
From suit. Have you filed an application before the suit court?
No.
Very good.
But Lordship, as per Order 1, Rule 10(2), at any stage, my lord, Lordships have some power on an application or on its own motion, my lord, to delete a party or add a party, my lord. I may not place that. Lordship is aware of Order 1, Rule 10(2).
Yes.
Now, my lord, this prayer or relief, my lord, does not survive anymore. My lord, assuming, my lord, I do not know whether they have served the writ of summons upon us, and time to file written statement 120 days is the mandatory period, which is over if they have served. I have not filed any written statement. My lord, today, even if the suit proceeds ex parte against me for non-filing of written statement, what relief can they get against me? My lord, that is the question I am putting to myself, my lord. Why should a corporate company, my lord, a government of undertaking company be saddled with a, my lord, a litigation, my lord, for no reason at all, my lord. My lord, lordship will kindly see, my lord, one document is not on record. My lord, on 3rd July 2024, my lord, we had, my lord, executed a fresh selling license.
Mr. Mal, we cannot go into any further document here
No,
because
my lord,
the scope of the appeal is very
just
limited.
by way of a fact.
No, the scope of appeal is very limited.
My lordship.
We cannot go because
yes.
we are only, it's an appeal from the section 8.
My lord, fresh
rejection.
agreement with the clients of Mr. Mitro has been executed.
And more so if you have not filed any written statement.
Yes.
We cannot look into
No,
that document.
my lord, lordship, I'll draw your lordship's attention to one order which appears at page 22 of my application. My lord, GA number 2. It's an order passed by the learned honorable single judge.
GA number 2 is your application.
Is my application
Right.
for deleting my name.
Yes, yes.
My lord, page 22.
22, yes.
My lord, short order, my lord, if I may read. It is submitted on behalf of the plaintiff that the hearing scheduled on 24th November 23 has been taken place. A hearing at the Food and Supply Department for issuance of selling license, my lord, in the name of the fresh partners with whom we had entered into an
Where the plaintiff is not a
party.
His name is not there.
And that is their main relief which has been sought. Participated. On behalf of the defendant number 124, it is submitted that a fresh
sorry
license...
to disturb you. This was in connection with this is in connection with the suit.
Yes.
The suit itself.
In the suit.
Well, yes.
On behalf of the defendant numbers 1 to 4, it is submitted that a fresh license in the name of Deepak Kumar Ganeriwal, Rohan Ganeriwal, and Anirudh Ganeriwal has been issued, clients of Mr. Mitro, by eliminating the name of the plaintiff, who had retired from the partnership in the joint name of the partners of which the original license stood. A copy of the license issued by the Director of Consumer Goods, Food and Supplies, Government of West Bengal on 1st December 23 is placed before the court, which is taken on record. Let this matter appear for. Now, my lord, this is the factual position, my lord.
Was this order passed prior or after the impugned order? Section 8 order?
Prior.
It was already on record in the suit on the date when the Section 8 was rejected. Right. All right.
Lord, based on this, my lord, my submission is very short. My lord, as on date, my lord,
the limited relief against you has already been, has spent its force in view of you having.
Absolutely. Well, today, if I am to continue as a party, as an array of defendants, my lord, and proceed, my lord, I will submission to make or any evidence to produce, or no reliefs can be granted, my lord. Even if I don't appear, my lord, what relief they can claim me against me ex parte is the question, my lord. So today, my lord, under Order 1, Rule 10, if I may just read it once.
Yes, yes. PCF টা ওনাকে দাও আমার আছে
Lordship, may I hand over?
No, we have.
My lord, suit in the name of wrong plaintiff. My lord, I am coming to Order 1, Rule 10, Sub Rule 2. Court may strike out or add parties. The court may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable court to effectually and completely to adjudicate upon, settle all question involved, be added. Now, my lord, as on today, my lord, at the cost of reputation, my lord, nothing survives against me, my lord. My lord, whether it's a arbitration or, my lord, the suit. My lord, I may be, my lord, added as a party in the arbitration, but against me also in the arbitration, my lord, I am not a necessary party. My lord, those are my humble submissions.
Thank you.
Ships wanted to know whether, my lord, the order was there before the court, my lord.
The dates will say that.
That is reflected in the order itself.
Oh.
Page 9 of the impugned order, paragraph 18. The impugned order. Page 9.
This was dated 4th December.
Only one more.
Right. Thank you, Mr.
My lord.
Yes, Mr. Mal.
My lord, only one more thing, my lord, before I
Yes,
conclude. My lord, if your lordship takes, my lord, the stay application once more, my lord, the original DPSL agreement would appear at 99, where the arbitration clause exists. My lord, page 108, clause 19 is the arbitration clause. My lord, it's between Bharat Petroleum on one side and the defendant number 1 and 2 and the plaintiff on the other side. Plaintiffs on the other
Which
side.
page should you look into?
My lord, I'm referring to page 108,
100.
clause 19. Is the arbitration clause. In the agreement, in between the plaintiffs, defendant number 1 and 2 on one side and Bharat Petroleum on the other side. Lordship, 19 is the arbitration clause. Any dispute or difference whatsoever arising out of or in connection with this agreement, including any question regarding its existence, validity, construction, interpretation, application, meaning, scope, operation, or effect of this contract or termination thereof, shall be referred to and finally resolved through arbitration as per the procedure mentioned here below. And the procedure is there, how the
Mr.
arbitration.
Mal, what is your response to a question which we are putting to you? If there are two separate arbitration agreements between different parties, not different parties here. Yes, different parties in the sense that BPCL was not a party to the partnership deed, obviously. If there are two separate agreements containing arbitration clauses, can the two arbitration clauses prompt the court to club the two arbitrations in a single arbitration proceeding? Can it be done?
My lord, in this case, my lord, the second arbitration clause, my lord, will exclude them. And whether there will be a necessary party in the second arbitration, my lord, is a question your lordship will have to adjudicate upon. They by no means can be a party to that arbitration between Bharat Petroleum and the existing partners or the partnership. And so far as the first arbitration clause, my lord, it has spent its force.
All right. Yes, Mr. Jain, what is your?
I'm little confused, my lord. Confused, my lord, because
Yes.
Lord, at one breath, my lord, Mr. Mal's submission, my lord, is that there is no arbitration agreement existing between the plaintiff, the rest of the defendants, and Mr. Mal's client. And just now, my lord, Mr. Mal refers to an agreement which starts at page 99
Yes.
and draws your lordship's attention at page 108, my lord, to
So his submission is twofold. One is the primary submission is very short, that the relief sought against them has spent its force because of the order recorded as recorded in the order of Justice Mukherjee.
my lord, to
And secondly, that this is an additional alternative argument, probably that is there is an arbitration clause between you and them
exactly.
separately.
So whether my lord lordships will have to, my
They are
lord,
not saying that there is no arbitration clause. Obviously, they are not a party to the partnership
partnership
deed.
deed. So my lord,
They,
that's why,
they
my
did
lord,
not argue that. It's very obvious, evident.
so my lord, that's why I'm confused, because my lord, is my learned friend's client trying to imply, my lord, that in view of the arbitration clause contained in this agreement, my lord, there is a existing dispute between me and Mr. Mal's client, my lord, which may be referred to arbitration. My lord, in my respectful submission, my lord, answer has to be no, my lord.
Why?
Because, my lord, there is no presently dispute arising out of this contract.
All
The
right.
contract which starts at page 108.
But the relief you have sought against them,
Yes, my lord, that I have. But, my lord, that is not pursuant to this agreement.
as per your plaint, no.
My lord, no. My lord, no. My lord, not because my relief is not simpliciter with regard to this agreement itself, my lord. Agreement starting.
Yes, your primary relief is that you are not getting the money, your name is not being deleted, and the relief against them, C, springs from that. That is your argument.
Yes, that.
It's a consequential relief.
Now, my lord,
Yes.
if my lord, I may respond to Mr. Mal's submission first, my lord. Lordships will kindly take the application filed by my learned friend's client, my lord, which is GA2.
But Mr. Jain, doesn't your relief against them also touch upon this this agreement with BPCL? Because you say that you cannot, you have to delete the names and all.
They have to
And
delete.
your rights with
Not just
BPCL.
this. It is not just my relief is not just emanating from this particular document, my lord. It is emanating, my lord, from their rules. The rules debars them, my lord.
All right.
There are statutory rules, my lord. My lord, I am saying, my lord, they have been flouting their own rules because the rule says the moment a deed of retirement is signed, my lord, they cannot supply a single, my lord, drop of petroleum products to any of the dealers till such time the names are removed.
Now they say, what is your response to that? 4th December order that they have removed and that has
Look,
been recorded.
when? After filing of the suit, my lord. That's why, my lord,
Yes,
I'll.
but as on today, you don't have any existing relief against them.
My lord, I do have, my lord. My relief is there, my lord. Lordship.
Relief is fruitless. It has become
My lord,
infructuous.
with the
Or
greatest
at
of,
least spent its force.
my lord, with greatest of humility, my lord, Lordship will kindly permit me to place Order 1, Rule 10. My lord, possibly, if my lords have to go by the submission of my lord, Mr. Mal, my lord, possibly we'll be rewriting statute, my lord. Lordship will kindly take Order
Tell
1.
us why. We have read Order 1 to 10.
Then my lord will kindly take the application. Because my lord.
Why do you say that? That it's.
Because my lord, law does not say that if after institution of suit, relief has spent its force, or my lord, they are no longer a necessary party, their name can be deleted. My lord, Order 1, Rule 10, my lord, proceeds on the premise that they were never a necessary or proper party.
No, Order 1, Rule 10 can be at any stage.
Can be at any stage, definitely,
Even
my
before
lord.
the date of passing of the degree, it can be done.
My lord, but then, provided, my lord, they were never ever a necessary party. Lordship will kindly permit me to place Order 1, Rule 10. At any stage, definitely, my lord, I bow down, my lord, but it does not say, my lord, that later on, my lord, then where is the question of order filing compromise petition?
Please place 10-2.
The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just. Now, my lord will kindly mark this. Order that the name of any party improperly joined. My lord, so my lord, this improperly joined has to be read since inception of my institution. It does not say, my lord, that now it is improperly.
Please carry on.
Improperly joined, whether as plaintiff or defendant be struck out. And that the name, my lord, possibly, my lord, we are not concerned with the next name, my lord, which is.
Start from the or after that.
My lord, sorry. And the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved.
So regarding removal, you say
improperly joined
has to be, yes, from the inception.
It has to be, because my lord, language does not say or. They are no longer a necessary party.
All right.
Language is very clear, my lord.
After or, there is no deletion provision.
My lord,
only addition.
My lord, had that been the case of my lord, Mr. Mul's client, my lord, that I was never ever a party, a necessary party or a proper party. My lord, then lordship, possibly I may have to, my lord, make much effort, my lord, in order to convince your lordships, my lord, that why they were a necessary party. Now, lordships will kindly take their application once, my lord. GA2.
Yes.
Possibly thereafter, my lord, I may not have to make any further submission. Paragraphs number 7, my lords. I'll just place 3 paragraphs, my lord.
Yes.
Paragraph number 7 at page 10, my lord.
Right.
The respondent number 2 petitioner, my lord, that is my lord, Mr. Mul's client, my lord, states that in view of the aforesaid orders being passed in view of the relief, so my lord, whatever actions they have taken, lordship will kindly, my lord, bear that in mind, lordships, that they have taken actions pursuant to orders passed in this very suit. They have not taken a step independently, my lord. Well, I had to approach court. This honorable court had to be, my lord, has been pleased to pass orders, my lord, and pursuant thereto, my lord, they have taken steps. The respondent number 2 petitioner states that in view of the aforesaid orders being passed and in view of the reliefs claimed for in the plaint filed by the plaintiff and so, no cause of action, if any, survives. So, my lord, even they admit that there was cause of action. Now it doesn't survive this. As against the defendant number 5, to continue to remain as a party defendant for adjudication of the dispute surviving between the plaintiff and the defendant number so-and-so. Now, my lord, paragraph 8. The respondent number 2 further states that the alleged grievances, if any, against the defendant number 5, respondent number 2 petitioner does not survive, and such question of the respondent number 2 petitioner's name to remain in the array of parties does not survive in the presence of respondent number 2 petitioner, the presence of defendant 5, respondent number 2. My lord will kindly mark this. Petitioner is not required for further adjudication. So it was required till one point of time. This is a clear admission. No longer, he says, my lord, I am no longer required. Till one point of time I was required. Now today I am not required. No, paragraph 9 also, my lord. That in view of provisions of Order 1 Rule 10.2, my lord, I also, my lord, take help of Order 1 Rule 10.2 of the Code of Civil Procedure. It is expedient that for the interest of justice, the name of the respondent number 2 petitioner be deleted from the array of the parties as the, my lord will now kindly mark this, as the respondent number 2 petitioner is no more necessary party. My lord, no more is nowhere there in statute. It says that who were not a necessary party and proper party to the instant dispute. Now, my lord, so my lord, by their own application, my lord, lordships, in my respectful submission, Order 10 Rule, Order 1 Rule 10 Sub Rule 2, my lord, has got no manner of applicability. And my lord, in fact, on the basis of this application itself, my lord, the application deserves to be dismissed because, my lord, this is, my lord, is in excess of, my lord, the statute, the provisions of the statute, my lord. My lord, this is, as regards, my lord, deletion of name of the respondent number 2 is concerned. Now, my lord,
5.
Respondent number 2, defendant number 5. That's respondent number 2. Yeah. Now, my lord, as regards, my lord, the appellant submissions concerned, my lord, there also I'm little confused, my lord, because, my lord, they are taking two stands, my lord. My lord, at one breath, my lord, they are saying that there is no cause of action against defendant numbers 2 to 4. 3 to 4. 3 and 4. So, my lord, if there is no cause of action against defendant number 3 and 4, my lord, where is the question of, my lord, me going for arbitration against them? My lord, there are twofold submission, my lord. First, my lord, they say that, my lord, there is a dispute, there is an existence of arbitration agreement, parties needs to be referred to arbitration. And another line of submission, my lord, is that, my lord, there is no cause of action against me. I am not at all in
Against defendants 3 and 4.
3 and 4. 3 and 4. My lord, I am on 3 and 4 only.
You are for 3 and 4, yes.
No, because, my lord, that was my lord, because
you are appearing for defendants 3 and 4.
No, my lord, I am for the plaintiff.
I'm sorry. Yes.
I am, my lord, the submissions advanced, my lord, by my
cause of action is defendant numbers 3 and 4, and therefore, yes. So, therefore, there is no question of any arbitration also then.
My lord, I am obliged. So, my lord, because, my lord, I have to, my lord, base my arguments, my lord, on one, my lord, footing. My lord, either there is existence of arbitration agreement, there is cause of action, I can pursue my remedy before the arbitrator. If there is no cause of action, my lord, in my respectful submission, Section 8 has got no manner of applicability. Then they could have filed Order 1 Rule 10.2, saying that there is no cause of action. I am an unnecessary party which has been impleted. Nothing prevented them. Lord, they having filed this application, my lord, itself, my lord, emphasizes the point, my lord, that there is cause of action, and cause of action which I have pleaded, my lord, is not at all governed by any agreement which contains arbitration clause.
We'll come back in a few minutes. Yes. Sorry.
No, no, ma'am. Lords, one thing, my lords, what I'd like to submit before I make my further submission, my lord. Possibly, my lord, my learned senior friend forgot to inform your lordships, my lord, that this is a matter arising out of a commercial suit. A commercial suit filed. My lord, before that, my lord, I had initially filed a suit before this honorable court in commercial division. That suit was dismissed. Because, my lord, I did not exhaust the remedy of section 12, mediation. Mediation initiated by me. Mediation failed. Thereafter, I had to file the second suit. So those orders are there if lordships want, my lord. If my lords kindly takes.
So what is your point? That they did not take this point at any or what?
My lord, because, my lord, if I had, my lord, in my respectful submission, had there been any, my lord, scope of any mediation or arbitration, my lord, nothing prevented my learned friends, client, my lord, to take that point before the mediator. They could have done that as well. My lord, after exhausting, my lord, the section 12A remedy, my lord, and because it became a non-starter, that non-starter report, my lords will find it's annexed to my plaint as well.
Probably Mr. Mitra will not dispute that. I mean, if that's
So
on record.
We have already, my lord, we have treaded that part. Means we have exhausted
It
that.
has come back after that?
After that,
Yes,
my lord,
right,
the suit
right,
has been
right.
filed. And another one very important thing,
Yes.
my lord, that none of the defendants filed the written statement within mandatory period of 120 days. So their right to defense, my lord, stands forfeited. In fact, an application was filed, my lord, belatedly, my lord, by my learned senior friends, client, my lord, that is the appellants before your lordships, my lord, seeking extension of time to file written statement before the learned senior.
What happened to that?
So that also has been dismissed on the same day. My lord, in that application, my lord, though a prayer was made to seeking extension of time to file written statement, my lord, there was no copy of written statement annexed to the application. And his lordships was pleased, my lord, to hold, my lord, that there is nothing on record to show. And that in as much as, my lord, the period of 120 days had expired, my lord, he could not grant the relief which was asked for.
All right.
And, my lord, and that order has, in fact, a review has been preferred against that order. My lord, that is pending. But because of stay granted by this honorable court, my lord, that review is pending. My lord, but those are the facts. Now, my lord, lordships were troubled with.
So what do you hint that by otherwise they have lost their defense? If it goes to arbitration, that will be revived.
My lord, that is the whole and sole purpose, my lord, of this exercise, my lord. Because, my lord, they know that today, my lord, possibly they are their rights to defend this instant suit, all of them, my lord, stands forfeited, my lord. In view of the mandatory provision, my lord, as amended, my lord.
All right.
My lord, the deed of partnership has been, my lord, placed before your lordship, my lord, and not troubling your lordship. It is an admitted position. That partnership deed had an arbitration clause which was only between the plaintiff, me, my lord, and the defendant, the appellant number 2.
That referred to partners. Now, partners, why shouldn't it include future partners also?
I'm grateful to your lordships. My lord will kindly now take second volume, which has my deed of dissolution. Second volume, first page, my lord, 111. Now, this was the proposed deed of dissolution, my lord. This is what I had at the then point of time, my lord, when I had filed the plaint, my lord.
Volume 2 of which one?
Volume 2 of their appeal, my lord.
Of GA1?
GA1.
এটা কি দিচ্ছেন? এটা নেই।
Or possibly, my lord.
Yes, we have it. Proposed dissolution deed.
Page 111.
111, yes.
Lordship will kindly see, by this proposed deed of dissolution, my lord, I retired. And there is no arbitration clause in this. And in fact, my lord, this was later on transcribed on a stamp paper. My lord, I did not have a copy of that, my lord, which has been filed by my learned senior friends client, my lord, subsequently in this proceeding, my lord, by way of supplementary affidavit. Lordship kindly takes the supplementary affidavit once, my lord.
If it's there, it's there. We are not.
No, because, my lord, I'll just.
You'll rely on something.
Yes, because I want to demonstrate, my lord, that the arbitration clause was given by the then partners also. The party novated because there's no continuity about arbitration clause. Lordship takes page 5 of the supplementary affidavit, my lord. This is the deed of dissolution. Affirmed, my lord, on 29th November 2024, my lord. My lords will see, my lords, it's deed of dissolution dated 1st of April 2022 between Pradeep Kumar Ganeriwala, Deepak Kumar Ganeriwala. Only 2 parties, my lord. 3 and 4 are not there. And lordships will see there is no arbitration clause in this deed of dissolution also. And thereafter, my lord, subsequent.
Is this one of the basis, the foundations of your suit? Your suit is purely based on the partnership deed.
No, and dissolution.
This also.
That
The
page
dissolution-
111 is, my lord, almost. I will not say.
So in your pleadings in the plaint,
Yes, yes.
you have referred to this also.
I did not refer to this
The
instrument,
stamped document, but you
but the
have stated
unstamped
that,
is 111.
no, you have referred to that unstamped document in your pleading
Yes,
also.
my page 111 is part of my plaint.
All right.
That's part of my plaint.
All right. All right.
Lordships will see there is no, my lord, arbitration clause in this agreement. And thereafter, subsequently, my lord, because I am not a party to that subsequent deed of partnership by which the defendant numbers, the appellant number 3 and 4 were inducted as partners of appellant number 1, my lord, and whether that has arbitration clause or not, my lord. That I am not aware of because I am not a party. So, my lord, lordship's query to me, my lord, that why not that partner should be deemed to be partner subsequently, my
Because
lord.
your cause of action is primarily based on that deed, which
That-
uses the expression partners.
No, my lord, my cause of action is on this date as well because I, my lord, ceased to exist as a partner because till that time, my lord, I was still a partner.
All
My
right.
lord, I ceased to be partner because of this and subsequent events as well. Because, my lord, there are obligations, my lord, which were to be performed by them.
Very well.
Now, if lordships will kindly pardon me, I will trouble your lordship again with GA2 once, my lord, because there are orders which are annexed to GA2, my lord. Lordships kindly take GA2. There are few orders, my lord, passed by the learned single judge, my lord.
Yes.
If lordships kindly turns to page 15.
Yes.
This is order of 18 September, my lord.
Right.
Affidavit of service filed in court is taken on record, my lord. All parties are there, my lord. All defendants are here. The plaintiff is an applicant and so the plaintiff seeks interim order in aid of final reliefs claimed in the suit and also ad interim orders. The main grievance of the plaintiff is that the plaintiff was a partner of the partnership firm of the defendant number 1 till March 18, 2022. The plaintiff says that even after the plaintiff has ceased to be partner, now my lord will kindly mark this, my lord. The license granted by the Ministry of Food and Supplies for operating the petrol diesel dispensing vending unit still continues to remain in the name of the partners of the defendant number 1, including the plaintiff. So my name continued there, my lord. My lord, that was also one of my grievance because my lord.
The Union of India is not a party here.
Union of India is not a party. Union of India is not a
This
party.
has to be corrected in the records of the Ministry of Food and Supplies then.
Yes, my lord.
BPCL cannot have any role there.
BPCL, no, BPCL, my lord, why because BPCL, my lord, is bound to ensure, my lord, that the name of the present partners are reflected in the.
Can the BPCL dictate terms to the Ministry of Food and Supplies?
Definitely not, my lord.
So you have not implemented them and there is no relief claimed against them.
No, there is no relief as regard government of Union of India is concerned.
Your relief has to be focused on BPCL, whatever the BPCL could do, apart from the other.
Yes, yes. Because, my lord, BPCL's rules, my lord, but BPCL is governed by its own rules, set of rules, my lord.
Yes, yes.
BPCL's rules says, my lord, that unless and until name of the existing partners are reflected in the certificate issued by the Union of India, my lord, they will not supply petrol. My lord, that is where the role of BPCL is.
Now they have themselves cancelled your name from their license.
After filing of suit, not before that, after orders are passed.
All right.
So, my lord, so till that day, my cause of action survived, and maybe today also it is there. My lord, I do not know. They are saying it's removed. When it has been removed, under what circumstances, my lord, I need to prove all of those, my lord.
All right.
still continues to remain in the name of the partners of the defendant number 1, including the plaintiff. The plaintiff apprehends that since his name still figures in the license, there is every likelihood that in case of any untoward incident, the plaintiff, despite having ceased to be a partner of the defendant number 1, may be hauled up for such incident and or consequences. The plaintiff says that his name should not be there in the license or the agreement for operating the petrol pump. My lord, this is where, my lord, I was trying to, my lord, put forward my point, my lord. Operating the petrol pump, and therefore seeks an injunction inter alia restraining the defendant numbers 1 to 4 from operating the petrol pump with a license wherein the plaintiff's name is still shown. On behalf of defendant numbers 1 to 4, it is submitted that they have taken all reasonable steps. So, my lord, till date also, my lord, they don't say that, my lord, my name is, they are still taking steps to protect the plaintiff from being hauled up for any untoward incident since he has ceased to be a partner. In fact, the defendant numbers 1 to 4 have written letter to department of so and so, so and so, so and so, which was duly received by the concerned department on so and so that the license on the renewal for next year shall be issued excluding. So, my lord, even till that date, my lord, my name existed. This is an admitted position.
Yes.
On behalf of defendant number 5, it is submitted, my lord, that is, my lord, Mr. Mull's client. The dispute is inter se between the partnership and its partners, including the plaintiff, who claims to have retired in March so and so. The defendant number 5 has nothing to do with the license issued by the Department of Food. My lord, what exactly fell from your lordships, my lord? Only issues the license under which the petroleum products are supplied by BPSL for being sold by the defendant number 1 at the petrol pump. Considering the submissions as aforesaid, I adjourn this matter till so and so that the parties, with the assistance of their respective advocates, can in the meantime sit and decide on the modalities by which the plaintiff's name can be expunged from the license issued by so and so that the plaintiff is not hauled up for any untoward incident despite having ceased to be partner. It is expected that the parties shall make best endeavor to come to an amicable out-of-court settlement. So, my lord, an opportunity was given then also. But still, my lord, we could not arrive at an amicable settlement. Then there is a subsequent order, if lordships kindly turns over, next page 18. It is submitted, lordships.
Yes, 18. Then.
4th October, my lord. It is submitted on behalf of defendant numbers 1, 2, 3, and 4. The
order was placed probably. Anyway,
Yes.
you can place it.
My lord, I will not.
No, you can. My lord. So, what is your submission on this 4th October order?
My lord, that time to time orders have been passed in this very suit. So, my lord,
Yes.
the submission of my learned senior friends, clients, my lord, that there is no cause of action or the illusory cause of action, my lord, I have tried to portray, my lord, possibly, my lord, is belied from all these orders, my lord, because, my lord, they have taken steps because, my lord, orders have been passed. They have been forced to take steps. Otherwise, they were sitting tight over the matter. It is not, my lord, that there is no cause of action. And not just against the defendant numbers 1 to 4, even against 5. And the 5 has also acted pursuant to orders passed by this honorable court only, not before that. And that is reflected from their application itself. It is submitted on behalf of so and so that the order dated so and so passed to this application was communicated to the department deputy director so and so. No reply. So even as on 4th October, my lord, my name existed in the records. They are still, my lord, in the process of taking steps. On behalf of the plaintiff, the market, my lord will kindly see this last paragraph. My lord, this is what, my lord, I was trying to submit, my lord, that they were violating their own rules, the BPCL. Last paragraph, my lord, at page 18. On behalf of plaintiff, marketing discipline guidelines of Bharat Petroleum Corporation Limited, in short BPCL, the defendant number 5 is placed before the court referring to chapter 5. It is submitted by the plaintiff that in case of any untoward incident that may occur during the operational of the retail outlet, the plaintiff is likely to be proceeded with or penalized because of his name still remains in the license issued by Food and Supplies Department. It is also the case of the plaintiff that in terms of the said guidelines, lordship will kindly mark this, BPCL ought to have stopped supplying petroleum products, my lord. Why did they continue supplying, knowing fully well, my lord? My lord, possibly, if my lord, lordship says, my lord, that my cause of action may not survive. My lord, tomorrow, if I may get a decree in terms of prayersy, possibly, my lord, I may be, my lord, inclined to bring forward that particular decree before the ministry, my lord, to demonstrate what kind of, my lord, organization is being run, my lord. That they themselves are flouting their own norms. The said guidelines, BPCL ought to have stopped supplying petroleum products for being sold in the said retail. Now, this is a violation, their own violation of their own rules. being specifically aware of the fact that the name of the plaintiff is still appearing in the license issued by Food and Supplies Department, though he has admittedly retired from partnership firm which operates the petroleum retail outlet, is continuing with the supplies. After hearing the parties, it appears that so and so should be served, my lord. So I was given direction, I served it. But my lord, they chose not to represent, my lord. I had served this matter to appear, made clear. Now, my lordship, last paragraph. It is made clear that in case any cause accrues against the partnership firm while proceeding with the partners of the said firm, it should be taken note of that the plaintiff has retired. So, my lord, a limited protection was given to me, my lord, because my lord, lordships knows, my lord, under that, my lord, there is penalty of going to imprisonment, my lord. So, my lord, I was apprehending that. I was scared of that. So, that limited protection was given, and it has been given in this very suit to me. Then, my lord, subsequent order, lordships, at page 20. It is submitted on behalf of respondent so-and-so that the joint director so-and-so has by notice dated 10th November 2023 called so-and-so for personal hearing. So still personal hearing is there. So my lord, why I am placing these orders, my lord?
Yes.
My lord, in fact, there is another order of 4th December at page
That
20.
was actually placed.
4th December, my lord. That was placed, my lord. I am not troubling you.
Yes, yes, you are right.
And lordships, the learned single judge, my lord, has taken note of these orders. And that is reflected in the order, impute, my lord. That it is not, my lord, that there is a illusory clause of action, and his lordships has been pleased, my lord, to hold that orders have been passed and steps also have been taken from time to time in aid of orders passed by this honorable court. So, my lord, now, my lord, I just made a note of what my learned senior friend, my lord, submitted, my lord. Lord, one limb of his submission, my lord, was that there is no contractual obligation between the plaintiff and the defendant number 3 and 4. My lord, I put a question to myself, my lord. If there is no contractual obligation, my lord, how can parties be referred to arbitration? My lord, he even submitted, my lord, that the plaint does not disclose any cause of action as against those defendants, my lord. Again, my lord, if there is no cause of action against, my lord, then the exercise of, my lord, referring the parties to arbitration will be in futility, my lord. My lord, if there is no cause of action, there is no cause of action. Nothing prevents my learned friends, clients, my lord, defendant number 3 and 4 to file an application seeking deletion. They have to come, file application and demonstrate before your lordships, my lord, that, my lord, there is no cause of action. I am unnecessary party. I am being dragged. They can get the... Thereafter, my lord, if there is, it's only me and defendant number. But that also, my lord, in view of, my lord, the subsequent resolution deed, my lord, I would say, my lord, the arbitration clause as between the defendant number 1 and plaintiff also no longer survives. Because that stands novated. And, my lord, the last submission, my lord, which my learned senior friend made was that though, my lord, there is no cause of action, my lord, the defendant number 3 and 4 are agreeable to go for arbitration. My lord, in my respectful submission, both submissions are self-contradictory, my lord. Either there is cause of action, my lord, then my learned senior friend needs to demonstrate that there is existence of arbitration agreement, and in view of that, my lord, parties are required to be referred to arbitration. And if there is no arbitration agreement, my lord, parties cannot be, in my respectful submission, my lord. My lord, now, as regards 2 judgments, my lord, cited. Before that, my lord, if I may just rely on one judgment, my lord, before I, my lord, distinguish the judgments. Lordships are aware, my lord, of the judgment of Sukanya holding, my lord.
That was referred to in one of these judgments.
Yes, my lord. Lord, reported in 2003, 5 SEC 531. Okay, this copy. My lords will kindly, in fact, my lord, this dispute also arose out of partnership deed. Almost similar situations, my lord. If lordships kindly takes paragraph 3. Thereafter, respondent number 1 filed suit number so-and-so in High Court of Bombay for dissolution of partnership firm and accounts and inter alia in favor of so-and-so. Respondent number 1 also took out notice of motion so-and-so for various interim reliefs, my lord. Now, paragraph 6, my lord. The appellants filed arbitration petition number so-and-so under section 8 of the Act, my lord. Paragraph 8, lordships?
Yes.
That application was opposed by respondent number 1 by contending that the subject matter of the suit is not between the contracting parties and the reliefs are claimed only against the respondent numbers 1 and 2. Well, almost identical situation. who are contracting parties but are claimed against remaining 23 parties who are purchasers, so-called tenants of the disputed flats. Paragraph 7, my lord. The High Court, by its judgment and order dated so and so, rejected the application under Section 8 of the Act. The court arrived at a conclusion that in the suit, apart from the relief or dissolution and accounts, the plaintiff has prayed for other reliefs. All the defendants to the suit are not parties. My lord will kindly mark this. All the defendants to the suits are not parties or partners in the partnership firm, and the terms of the partnership deed, including the arbitration clause, are not binding on them. Only part of the subject matter could at most be referred to arbitration. Further, there is no power conferred on the court to add parties who are not parties to the agreement in the arbitration proceedings. The court also negated the alternative prayer for referring the part of subject matter in respect of those parties who are parties to the partnership agreement, which contains arbitral clause, my lord. Now, my lord, paragraph 11. For appreciating, my lords. For appreciating the contentions raised by the learned counsel for the parties, we would refer to the relevant provisions, namely section 5 and 8 of the Act. My lords. Now, paragraph 12, my lord. For interpretation of section 8, section 5 would have no bearing because it only contemplates that it is in matters governed by part 1 of the Act, judicial authority shall not intervene except where so provided in the Act. Except section 8, there is no other provision in the Act that in a pending suit, the disputes is required to be referred to the arbitrator. Further, my lord will kindly mark this. Further, the matter is not required to be referred to the arbitral tribunal if the parties to the arbitration agreement have not filed any such application for referring the dispute to the arbitrator. In a pending suit, such application is not filed before submitting first statement on the substance of dispute, or such application is not accompanied by the original arbitration agreement or duly certified copy thereof. My lord, they did not even, my lord, adhere to this, my lord. The section 8 application did not contain this. Original arbitration agreement was not there.
Or duly certified copy also?
No. Subject to correction, my lord.
Take that point. Was it
No,
one of the grounds?
I have not taken that point.
Probably the learned single judge did not take that.
Even I have not taken. Also, I have not
So
taken.
yes.
But the statute says so, my lords. This would therefore mean that the Arbitration Act does not oust the jurisdiction of civil court to decide the dispute in case where the parties to the arbitration agreement do not take appropriate steps contemplated under sections 1 and 2 of section 8 of the Act. Secondly, now, my lord, paragraph 13 is very important. There is no provision in the Act when the subject matter of the suit includes subject matter of the arbitration agreement as well as other disputes, the matter is required to be referred to arbitration. There is no provision. There is also no provision for splitting the cause or parties and referring the subject matter of the suit to the arbitrators. Thirdly, para 14. There is no provision as to what is required to be done in a case where some of the parties to the suit are not parties to the arbitration agreement. As against this, under section 24 of the arbitration, referring to 1940 Act, some of the parties to a suit could apply that the matters in the difference between them be referred to arbitration, and the court may refer the same to arbitration provided that the same can be separated from the rest of the subject matter of the suit. This section also provided that the suit would continue so far as it related to parties who have not joined. My lord, possibly we are not concerned with this. Now, paragraph 15, my lord. The relevant language used in section 8 is in a matter which is a subject of an arbitration agreement. My lord, that is of paramount importance, my lord. The court is required to refer the parties to arbitration. Therefore, the suit should be in respect of a matter which the parties have agreed to refer and which comes within the ambit of arbitration agreement. Where, however, a suit is commenced as to a matter which lies outside the arbitration agreement and also between some of the parties who are not parties to the arbitration agreement, there is no question of application of section 8. The words a matter indicate that the entire subject matter of the suit should be subject matter of arbitration agreement. My lord, possibly, my lord, paragraph 15 of Sukanya.
16 also.
The next question which requires consideration is even if there is no provision for partly referring the dispute to arbitration, whether such a course is possible under section 8 of the Act. In our view, it would be difficult to give an interpretation to section 8. I'm obliged. Where under which bifurcation of the cause of action, that is to say the subject matter of the suit, or in some cases bifurcation of suit between the parties who are parties to the arbitration agreement and others.
This was interpreted by Justice Bhattacharya in the judgment cited by Mr.
Yes, ma'am.
Although you are not bound by a single judge's judgment, but it has persuasive value.
Definitely, but my lord will kindly see what was my lord, in what context the judgment was delivered, my lord. If I may just, my lord, refer to the
Yes.
paragraphs which my learned senior friend, my lord, referred to, my lord. My lord, first of all, my lord, this dispute arose between, my lord, parties are not named. If my lord, if I may straight away come to paragraph 5, which was placed, my lord.
Hmm.
Mr. So and so learned senior counsel appearing for the
6 was placed actually.
Please, oh sorry, my lord, I wrote 5 also. Mr. So and so learned senior counsel appearing for the plaintiff supposes the reference on the ground that the disputes against the different defendants are inextricably interlinked and are incapable of piecemeal adjudication. Counsel submits that the reliefs prayed for by IFGL are geared to bifurcate composite causes of action and split necessary and proper parties. It is submitted that the disputes forming the subject matter of the suit are not covered by the arbitration agreement and do not arise out of limited scope of the purchase orders to which the arbitration agreement relates. Counsel places reliance on Sukanya Holding, my lord, which I just relied, my lord, and the recent pronouncement of Supreme Court in Vidya Dolia, Durga Trading Corporation. My lord, thereafter, my lord, then a senior friend, my lord, possibly placed paragraph 24, my lord.
24 onwards, yes.
My lord sees, thus it is evident from the statements made in the plaint that, my lord, lordships were hearing, my lord, the statements made in the plaint, my lord. What were the statements made in the plaint? So lordships have to see what are the statements made in my plaint, my lord. Thus, it is evident from the statements made in the plaint that the suit has been filed against two groups of defendants with separate claims. So, my lord, there were reliefs between two groups, separate claim. My lord, my claim is, my lord, I have not bifurcated my claim. My claim is one-fold against all. So, my lord, possibly, my lord, this is a point of distinction, my lord, and in my respectful submission, my lord, I need not trouble your lordship any further, my lord, with regard to this particular judgment, my lord, because the premise on which this order was passed, my lord, the plaint, my lord, was couched, my lord, in such a manner, my lord, there were two set of defendants and two set of reliefs. And, my lord,
It was held in this judgment in paragraph 32 that Sukanya Holding is no longer a relevant factor for the court to consider this after the amendment.
In fact, subject to correction, my lord, as far as I know, my lord, Sukanya Holding still holds the field, my lord, and it has not been overruled. In fact, it has been referred by a larger bench and, my lord, continues, subject to correction, my lord. So, my lord, if that, my lord, I would say, my lord, that if such an observation has been made, my lord, that is per inquiry, my lord. That observation, my lord, possibly, my lord, cannot and should not sway my lords, my lord. And in any event, if lordship kindly sees paragraph 24 itself, my lord. Lord, this is the distinguishing feature, my lord. Because, my lord, that suit, my lord, had two separate set of, and my lord, what his lordships, my lord, was pleased to do, my lord, with regard to this particular matter was, my lord, refer one set of party to the arbitration. It is, my lord, not that...
No, it was held here also that NN Global has distinguished that...
NN Global, my lord, is bad law, no, my lord. NN Global has been super, my lord, after interplay between, my lord, arbitration and my lord, that is no longer a good law, my lord. And then global, my lord, has been overruled. My lord, I would still, my lord, rely on Sukanya Holding. My lord, the second judgment, my lord, which my learned senior friend said, where is that? Oh, yeah, yes. Reported in 2024 SEC. My lord, their lordships, my lord, were following the judgment rendered by, my lord, the Constitution Bench judgment in Cox and Kings, my lord. Lordships knows Cox and Kings, my lord, the ratio decided by Honorable Supreme Court, my lord. The lordships were deciding, my lord, the doctrine of company, my lord. That, my lord, in greatest of, my lord, respect, my lord, that the ratio which has been decided, my lord, cannot be stretched, my lord, my lord, to impart, my lord, to such an extent, my lord, that everyone and anyone under umbrella will have to go for arbitration. My lord, then what will happen to section 7, my lord, of arbitration? That is rendered ocious. Lordship, can you take section 7?
Yes.
Lordships, can you take? My lord, that has to be read only, my lord, And that also, my lord, possibly their lordships were trying to lift the corporate veil. My lord, there, my lord, that lordships kindly take section 7, arbitration agreement. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes, whichever, sorry, my lord.
You continue. Please continue. We'll catch up.
All lordships will definitely all or certain disputes which have arisen or which may arise between them in respect of defined legal relationship, whether contractual or not. An arbitration, subsection 2, my lord. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration, now, my lord, subsection 3, my lord, which is very important. An arbitration agreement shall be in writing. It's a mandate, my lord. So it has to be in writing. My lord, there is no existence of arbitration agreement. An arbitration agreement is in writing if it is contained in a document signed by parties, exchange of letters. So, my lord, it can also be by way of exchange of letters, communication, anything. My lord, my lord, what the legislatures, my lord, intended by inserting section 7 or by incorporating section 7, my lord, is basically, my lord.
Mr. Jain, what has been done by the Supreme Court is not stretch the definition of an arbitration agreement. No. Section 8 says a party to an arbitration agreement. So what Supreme Court has done is stretch party, not arbitration agreement. Arbitration agreement till now remains set in if not in stone in section 7. But the expression party to the arbitration agreement, the party has been, extended beyond recognition now.
Beyond
by the Supreme
recognition,
Court.
my lord, then
Almost beyond recognition.
and conduct, because
so many factors are there. Yes, those factors have to
correct.
come in.
So
Conduct and other things also. The language of the agreement also has to be seen.
I bow down, my lord.
Yes.
So, my lord, possibly, my lord, I have been able to demonstrate, my lord, that as regards my original agreement, partnership agreement,
Yes.
which contained arbitration clause, stood novated, my lord, and the intention of the parties, my lord, was no longer to even the intention of the plaintiff and the defendant number 1 and 2 was no longer, my lord, there, my lord, to go for an arbitration agreement. So to go for an arbitration, my lord. And that is why, my lord, there was no arbitration clause in the deed of dissolution, my lord. And admittedly, my lord, there is no arbitration existing at least between the plaintiff and the defendant number 5. And my lord, my suit is a comprehensive suit, my lord.
Yes.
There are reliefs claimed against all the defendants. The reliefs in my suit cannot be bifurcated, nor the parties can be bifurcated. And lordships, the one last submission, my lord, which I'd like to make, my lord, on last occasion, my lord, I had placed an order passed by Honorable Supreme Court in an SLB preferred by me, my lord. If lordship kindly take that order.
What is that?
My lord, on last occasion, my lord, I handed it over, lordships.
Last occasion.
Order dated, my
Yeah,
lord,
please.
2nd of December 2024, my lords.
Right.
My lords. If lordships kindly takes page 2, my lord. Paragraph 4 of this order, my lord. Dinam. Last time to the
এটা দুটো কপি এখানে চলেছে জানেন এটা একটা ওনার কাছে আছে তো
My lords, I have one
page
more.
2. Yes, this is in connection with the
This-
present case.
Yes,
Right.
this case.
It goes without.
Because, my lord, lordships will recollect, my lord, this honorable court was pleased to grant
Oh,
liberty.
that Mr. Moll was referring. Yes.
Was pleased to grant liberty. My lord, lordships will kindly turn to paragraph 4.
Yes.
It goes without saying that the High Court will also keep in mind that the petitioner is the master of the suit. Lord, it is my suit, my lord.
You are only to keep in mind.
Definitely, lordships. So, my lord, I am the master of the suit.
Can anybody else be the master of the suit?
Cannot be, my
If a
lord.
High Court does not keep this in mind, then the High Court is not worth being called a High Court.
No, my lord.
We definitely will keep in mind that the plaintiff is the master of the suit, and
No,
generally
lordships will
plaintiffs file suits.
Lordships always keeps that in mind. My lord,
There may be some exceptions we don't know. Till date, I have not.
My lord, I wouldn't want to say much, my lord. This is the observation of the Honorable Supreme Court, my lord. I will
bow down
not
to
say.
that. We keep it in our mind that the plaintiff files the suit. Counterclaims is not filed by the plaintiff. It's not a suit. It has the nature of a suit. Counterclaim we thought of, but counterclaim is not a suit. It has the status of a suit. Someday, probably, but these are being now. Recently, we came across a judgment of the Apex Court that title does not pass unless a sale deed is registered. So that landmark judgment has been flashed in many places as a landmark judgment.
Possibly Justice Oak's judgment.
Whoever's judgment, I mean, the Supreme Court. So it's a landmark judgment now. Before that, it was not law.
No, it was.
It was not. Anyway, Mr. Jain, let us not
Now, my lord,
jeopardize our own seats.
no,
Yes.
my lord, if lord,
So,
if I may
yes,
trouble your
so
lordship with the
this
impute order.
observation you are also relying on, that master of the suit is the plaintiff, so
Plaintiff.
we have to keep that
Yes.
in mind. Definitely.
Now, if lordships kindly take the impugned order.
Yes. The impugned order.
Lordship. If my lord straight away turns to my lord, paragraph 2 is the reliefs, my lord, which I have paragraph 2, internal page 2 of the impugned order is the reliefs, my lord, which I have
Right.
claimed. Paragraph 3, my lord, at page 3.
Hmm.
On 23rd of August, my lord, his lordship, my lord, refers to the main partnership agreement, my lord. The plaintiff and the defendant number 2 entered into a partnership deed for business under the name and style of Messrs. Exchange with effect from 4th of August 1994, having equal share in the said business. The partnership business dealing with petroleum products is supplied by defendant number firm, namely Bharat Petroleum, and the defendant number 1 is referred to as dealer, retail outlet.
So, Mr. Jain, we have to rise a bit early today before recess because my learned brother has a different bench. So around 12:55 we'll be rising. You have 6-7 minutes.
I will just place this order.
Let us complete this order.
Just, and I am done. In the year 2017-18, certain disputes, my lord, you may skip paragraph 4. Paragraph 5, my lord. The plaintiff in bona fide and in good faith, without asking any questions to the defendant number 2, accepted whatever money was being paid by the defendant numbers 1 and 2 to the plaintiff as the plaintiff's share or entitlement from the profit of the defendant number 1 as one of the partner of the defendant number 1 firm, as per advice of the defendant. Now, lordship will kindly mark this. As per advice of the defendant number 5, my lord, Mr. Mull's client, and as per the format provided by the defendant number 5, the plaintiff and the defendant number 1, the defendant number 2, and the defendant number 5 have entered into fresh agreement in the year 2020, my lord. That is the agreement, my lord, which my Mr. Mull was referring to, my lord. In the lordship may skip paragraph 6, my lord. Paragraph 7, my lord. The defendant number 2 further conveyed such desire of the plaintiff to the defendant number 5, since the defendant number 1 was the retail outlet. It was governed by the rules and guidelines framed by the defendant number 5. Time to time, and it was duly accepted and acknowledged by the defendant number 5. Further, the deed of retirement was prepared. My lord, lordship's query was whether I have referred to that or not. Further, a deed of retirement was prepared in accordance with the format provided by the defendant number 5, to which the plaintiff had signed without having much to say, and the plaintiff retired from the defendant number 1 firm on or about March 2022. Then, my lord, paragraph 9. On and from 1st April 2022, the constitution of the defendant number 1 stood changed, and the plaintiff is no longer as partner to the defendant number 1 firm. The defendant numbers 3 and 4 have been inducted as partners, and the defendant number 1 with defendant number 2. Now, my lord, if lordship takes paragraph 11, my lord, the contention, my lord, this was the contention of my learned senior friend's client, the appellant before your lordship. The contention of the defendants that as per clause 12 of the partnership deed dated so and so, the parties are required to be referred to arbitration. So, my lord, this was the contention. The defendants say that the defendant numbers 2 to 4 have recorded the factum of retirement of the plaintiff from the defendant number firm in the records of all government departments, authorities, and concerns bodies. They submit that name of the plaintiff does not appear as partner in the defendant number firm register. But, my lord, they don't say as to when this has been done. Now, para 13. The defendants say that the claims made by the plaintiff in the present suit are within the compass of clause 12 of the partnership deed dated so and so, entered between the plaintiff and the defendant number 2. The defendants say that the plaintiff has inducted. Now, my lord will kindly see this. My lord will kindly mark this. The defendants say that the plaintiff has inducted the defendant numbers 3 to 5 as defendants in the present suit only to avoid arbitration clause, as there is no cause of action. So, if my lord, there is no cause of action, my lord, I put a question to myself. Lord, how can they be referred to arbitration? And same submission has been made before your lordships also today, my lord. Against the defendant numbers 3 to 5 in the present suit. In paragraph number, then lordships, my lord, I will not trouble your lordship with paragraph 14. 15 also lordship may skip. Then lordships, paragraph 17 has been placed before your lordship. I am not troubling. My lord will kindly straight away come to paragraph 18 now, my lord. 18, 19, and my lord, that's it. Because my lord, lordships are sitting in a court of appeal, my lord. Lordships have to see, my lord, what is illegality or perversity in the issued order, my lord. Upon, now my lord will kindly see paragraph 18. Upon combined reading of the whole plaint, it reveals that the plaintiff has categorically made claim against the defendant numbers 3, 4, and 5 also. So, my lord, this is a clear finding of the honored single judge. After induction of defendant numbers 3 and 4 as partners of the defendant number 1 with defendant number 2, even after the defendants are using the name of the plaintiff, and to that effect, lordship will kindly mark this, and to that effect, this court by an order that is so and so, so and so, so and so has passed several orders, several directions for removal of the name of the plaintiff or license. My lord, his lordship takes note of those orders as well. Para 19. This court finds that the plaintiff has made the defendant numbers 3 to 5 as a party to the suit, and specific case, my lords will kindly mark, has been made out against the defendant numbers 3 to 5, and they have not taken any steps for removal of the name of the plaintiff from the record of the defendant number 1, and also not paid the amount to the plaintiff, which the plaintiff is entitled to get the same after retirement as partners of the defendant number 1. And admittedly, the defendant numbers 3 to 5, now lordship will kindly mark this, and admittedly, the defendant numbers 3 to 5 are not parties to the partnership deed entered between the plaintiff and the defendant number 2, and thus the clause 12 of the partnership deed is not applicable against defendant numbers 3 to 5. The case made out by the defendants that the plaintiff has set up illusory cause of action against the defendant numbers 3 to 5 is not sustainable. And my lord, this so my lord, in my respectful submission, there is no illegality or perversity in the order. Order is absolutely correct, my lord. Lordships will kindly dismiss the appeal, my lord. And my lord, the interim order which has been passed by your lordships, my lord, may kindly be vacated, my lord, by staying the suit, my lord. And the plaintiff, my lord, maybe.
We'll take the rejoinder on the next day. Next Wednesday.
Very short. Next Wednesday.
Next Wednesday.
Yes, we take up origins advantage division bench only.
We got short reply.
Heard learned senior counsel appearing for the appellants, comma, the learned counsel for the respondent number 2, as well as learned counsel for the plaintiff stroke respondent number 1. Push up, next para. For rejoinder arguments on behalf of the appellants and the respondent number 2, let the matter be listed next on. Yes.
Will it be a week after that, subject to my lords?
We'll lose continuity, Mr. Jain. You will not be there.
Then, my lord, will my lords permit me to join online, my lord?
Yes, absolutely. Always. It's always in our court. We always come. On February 12, 19. Thank you. February 19, 2020.
Grateful, lordship. Keep
Thank you.
For inclusion in matter is hearing matter, my lord.
Hearing, no. We are not taking hearing matters. Yes.
Not a substitution application.
Application. Yes.
Your Lordship, may I be permitted mention a matter for inclusion? Order 41.
Yes.
For inclusion, ma'am.
Application.
No, my lord. Appeal and my lord is.
Appeal hearing we are not taking.
Not here. That 5 days.
So put the heading application there. Yes.
Application for restoration of
Application.
security.
Permitted for mentioning order 41.
Yes.
But may I have your lordship's leave? My lord, well, the matter is appearing as item number 97 of your lordship's list. It's an appeal. Lordship had granted an interim stay of the decree of eviction till 15th of February. Now, my lord, I was also directed to file requisite number of paper books and file an affidavit in reply to the affidavit in opposition filed by the respondent to my stay application. My lord, I am in default. My lord, I am out of time by more than 15 days now in filing the reply and the paper books. But my lord, I'm only praying, my lord, if your lordship could extend the time for 10 days or 2 weeks, my lord, I'll be.
It will appear as to be mentioned tomorrow. We'll extend the time and then it will go revert back to the list, hearing list.
My lord, may I be permitted to mention for
It
application?
to be mentioned in Kaldi.
May I
Yes.
be permitted to mention for application?
Yes.
One, my lord. I'm asking for the respondent, my lord.
Yes.
The report, my lord, 2 exhibits.
Yes, yes. So you have taken his.
Yes, my lord, brought the exhibits as well. Exhibit 1 and 2.
Your client had taken.
My lord, these are the original which has.
No, no. Keep it with you. File it in the department. We'll direct that to the. The learned advocate for the respondent number 1 submits on instruction that his client, the plaintiff stroke respondent number 1 had indeed withdrawn the originals of the exhibits 1 and 2 in the code below by furnishing photocopies thereof, which is why the said original exhibits could not be traced in the records. Full stop. The learned advocate submits further that he is the originals have been handed over to him by his client. Full stop. Accordingly, the appellant shall, the respondent number 1 shall furnish the originals of exhibit numbers 1 and 2 in the department, which upon being furnished shall be accepted by the department, and a fresh revised report shall be given by the department as to whether the appeal is otherwise ready for hearing. Full stop. Upon such fresh report being given, liberty is given to the parties to mention the matter for inclusion in the list.
Sir, may I pray?
Mention the appeal for inclusion in the list.
Seek one indulgence.
Yes.
My lord, the
It was already appearing in the list for hearing.
It was appearing, it went out because of the LCR being not tagged. And the respondent number 1 is, my lord, now bedridden, and my eviction suit because of this pendency of this appeal arising out of a probate, my lord.
No, Mr.
grant of
Chatterjee, let the
probate.
defects be cured first. Let the reverse report come.
Only these 2 were not there, my lord.
Yes, your client's fault.
Very
That
good.
too, after we asked you, then you only inquired and should have taken care of that.
Very good.
No, we cannot add right now. Yes, go next.
Item number 2. My lord, my lord is making returnable for a fresh report.
Liberty to mention after the fresh report is filed. Yes.
My lord, I am for the appellant, my lord.
They appear for respondent number 1, HDFC Bank.
Mr. Chakraborty, defects have been removed. Yes, sufficiently stamped.
My lord, out of the respondents, my lord, defendant.
You are for respondent number 1. Yes.
Respondent number, my lord, 1 and 4 could be served. 2 and 3, in spite of 3 times attempt being made, could not be served. None of them appeared and now contested before the court below. My lord,
What was the suit for? You were the plaintiff.
I am the plaintiff. My suit was dismissed ex parte. My lord, regarding the loss of share, my lord, and now I am praying that those shares may not be transferred during pendency of the appeal.
Learned counsel for the, you have filed your affidavit of service.
Yes, these are three affidavits of service. Affidavit of service.
What is the endorsement in the track report?
My lord, endorsement, my lord, in the track report, left out of 4, 2 has been served.
2 and 3 have not been served.
2 and 3, my lord, that 2 actually, my friend is appearing for respondent number 1, and respondent number 2 is the transferring agent of the respondent number 1.
No, 2 and 3 have not been served.
Not been served, my lord. Attempts were made on thrice. My lord, they could not be served. My lord, they also did not contest in the court.
Neither 2 nor 3 contested.
No.
Learned counsel for the petitioner files affidavits of service which are kept on record. Whose it transpires that although service has been effected on respondent number 1, comma, which is represented in court today by counsel, and respondent number 4, comma, no effective service could be no service could be effected on respondent numbers 2 and 3 despite repeated effort. Full stop. Although proper service has not been effected on the respondent numbers 2 and 3, comma, learned counsel for the petitioner contends that the said respondents did not contest the suit in the court below, and as such, service of notice of the application be dispensed with on the said respondents. Full stop. There being substance in such contention, comma, service of copies of the application on the respondent numbers 2 and 3 is dispensed with. Full stop. Yes, what do you say about the injunction?
My injunction is, my lord, I have purchased the shares, the suit shares, and my lord, that thereafter it was lost, my lord. My lord,
you have claimed title to the shares. Why was it dismissed?
Dismissed, my lord, peculiar, my lord. I have not registered my name before the company, and before that, the original shares with the transfer deeds were lost. The court contended that why you have not been provided with the bonus share. My lord, if I do not register my name, and question of giving bonus share to me does not arise. Second stand is that respondent number 4 was is the registered shareholder, and I have made him party. He did not contest he appeared thereafter discontinued the suit. Court stand is why you have not brought the respondent number 4, that means defendant number 4 as a witness to the case to prove your case. My lord, he is a defendant. He has been made a party. He cannot maybe compelled to come to adduce evidence.
Yes, what do you say? You are for the bank.
Yes, Lordship, I sought for instructions, Lordship, but I could not get, so I am not in a position to file. They are unable to provide. It's a old matter, so bank official is not in a position to provide the.
We are granting injunction. The present appeal arises. The present appeal arises out of the ex parte dismissal of a suit filed by the plaintiff appellant seeking declaration that the plaintiff stroke appellant is the bona fide shareholder in respect of bona fide shareholder or bona fide holder?
Bona fide holder of the share.
Bona fide holder in respect of 200 equity shares and for consequential reliefs. Puts up next para. Upon hearing learned counsel for the appellant and the appearing respondent number 1, comma, we are of the opinion that a prima facie case for hearing the appeal on merits has been made out. Push up. Accordingly, the respondents are restrained by an order of injunction from transferring, alienating, and or dealing with the subject shares and or issuing any duplicate shares in favor of any third party during pendency of the appeal. Full stop. Can 8377 of 2019 is disposed of in the light of the above observations? There will be no rise to cost. The appellant shall put in due requisition. In view of non-appearance of the respondent numbers 2 and 3 in the court below, comma, service of notice of appeal on the said respondents is dispensed with. But 4 appeared.
4 appeared, but subsequently discontinued.
Even then you have to give a notice. For your benefit only, because due requisite shall be put in by the appellant within a week for service of notice of the appeal on the respondent number 4, push up, service on respondent number 1 is dispensed with in view of appearance of the said respondent through its learned advocate. Who's up next para? The trial court records be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the appellant. Who's of liberty to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Item number 3, my lord, I am.
Lordship, I beg to appear on behalf of the respondent.
In the last occasion, it was directed.
No objection, you have taken no objection.
Already, phrase wakalatnama already been filed along with the endorsement of no objection by the previous engaged advocate.
Very good. When did you file? Give the entry number. The note. আজকে অনিন্দিতা আসেনি কেন? আসেনি কেন?
Liberty may kindly be given to file affidavit in opposition in respect of 4 CAN applications.
Let us hear him first. The learned advocate for the respondent submits that a proper wakalatnama has been filed after obtaining no objection from the erstwhile learned advocate for the respondent. Puts up a photocopy thereof is also handed over in court today and kept on record. Puts up accordingly, the appeal be deemed to stand cured of the defect regarding filing of erroneous wakalatnama by the on behalf of the respondent. Puts up the application is now taken up for hearing. Yes, what are the applications for?
My lord, application. My lord, one application, old number that is CAN 1 7212. That was the
7212.
application filed by the executor who has already expired, my lord.
Deceased
And
appellant.
that's why, my lord, CAN 3 was filed. The present executor. There were 2 executors in a will.
You are challenging what? The
I am challenging
refusal of probate.
No, my lord. I am challenging the succession certificate which has been obtained by my learned friend by suppressing the fact, my lord.
Suppressing what? Your probate?
Yes, my lord. They have filed a succession case before the City Civil Court at Calcutta Chief Justice, wherein my client entered appearance and say that a will is already executed where he has been appointed as an executor. Court has given a time to produce that will.
The will is probated according to you?
No, that is pending for adjudication. On the next day, when the date was fixed for production of that will, prior to that, my learned friend clients mentioned the matter, put up the matter, and earlier date was fixed, and on that date only the succession was granted. That's why we have challenged.
One of the executor who was conducting, he has died.
He has died.
Now you seek to implead whom? The other executor.
Other executor who is Pradeep Kumar. And it is all in my section in my CAN 4 application, my lord. I have already executed the will, my lord. We have the name of the my lord. Kindly come to page 7, my lord. Annexure 8, death certificate of Brojan Mandal, my lord. And thereafter, my lord, will we have the name
The
of
substitution application has been filed within time.
Yes, my lord.
And what is this leave to proceed appeal? Why?
Because, my lord, I filed substitution application being CAN number 3. Objection was read by my learned friend. So, if I abandon precaution, I have filed because they have taken a point in that opposition that's under section 211 of Succession Act. He is not the legal heir. That is true. He is not the legal heir. But under section 213.
13 is there, yes.
That's why I for abandon it for in precaution, my lord. I filed section 4, my lord. CAN number 4.
213 requires a leave. Does not require any leave. Yes. Why shouldn't we permit him to be added? He is the executor, other executor.
Yes,
ma'am.
He is claiming on the basis of a will, which is disputed.
At the very outset,
Lordship. Request only one thing, my lord. My lord, kindly come to page 10, internal page 3 of the will, my lord.
Which page? Which application?
CAN 4. CAN 4, CAN 3, both.
Page 10.
Page 10, my lord. Internal page 3 of the will.
Yes.
First, second, third, fourth, fifth paragraph, last paragraph. I appoint my elder brother-in-law, Pradeep Kumar, son of
And Bojana, yes, very well.
And
So
he
the
has filed
probate, you have not yet obtained the probate.
No, my lord. That is pending.
Yes, what do you say?
Yes, Lordship. At the very outset, I would like to state that the will, as alleged by the appellants, is a forced and fabricated document.
Are you contesting the probate proceeding?
Yes.
At present, Your Lordship, there exist no probate proceedings. Whatever proceedings initiated by the deceased executor was dismissed for default.
This case is there.
Indian Succession Act.
No, no. Second bench, 60 at Calcutta, matter is pending.
This case is there.
Lordship, liberty may kindly been given to file the affidavit in opposition.
Why opposition to substitution application? What is your contention? On what ground you will file opposition? You make your arguments orally. We won't time on affidavits in opposition unnecessarily. You will record your arguments. What is your objection to this? Unless you want to bring some fact on record by oath. You make your arguments on law. Why not?
But there exist checkered
You
history.
say that there is no probate has been granted to the will, and you also dispute the existence of the will.
As well as under section 213, there is a prohibition upon the executor to exercise his right as an executor unless and until a appropriate court grant probate of the alleged willing. Lordship,
Let us come to that.
section 213 of Indian Succession Act.
Yes.
The annexure carry out.
Till date,
Please come to 211(1).
Yes.
It's more or less settled now. During pendency of a probate proceeding, an executor can represent the estate. Who is the legatee?
Legatee is my lord, son of the executor who has expired, and
your son.
No, my lord, and son
Lordship,
of the present.
suspicious circumstances exist.
No, you will record your submission that you dispute the existence of the will and you say it's a manufactured will and no probate has been granted, and also 213. But under 211(1 will permit him to be added, and he will, because somebody has to prosecute the appeal. He's the only one left.
Lordship, but kindly appreciate the fact that the present appeal was preferred by one Brojendranath Mondal claiming to be the executor of an alleged will. A present appeal filed in the year 2018. Thereafter, no steps taken by the deceased appellant to get the matter heard. Lordship, kindly
Deceased appellant cannot take any steps.
Lordship, deceased appellants.
When did he die?
He died in the year 2004. Alleged will alleged to be made on in the year 2017. Lordship,
when did Brojendra die?
Brojendranath Mondal died
April.
24.
Both of you don't argue together. You prompt him, he will argue.
Lordship,
One of you.
Brojendranath Mondal died on 24th April 2024.
Very well. And this is under Order 20 Rule 10, not 9. So there is no limitation period.
But
9 regards do not apply.
But Lordship, the present appeal
Whose
was
phone is vibrating? Either of your phones are vibrating. Yes.
present.
Your phone.
Yes. Lordship, I grant pardon. Okay.
No,
Beg
it's
pardon.
all.
Lordship, present appeal was filed by the said Brojendranath Mondal as an intervener, and accordingly, an application was filed for seeking leave to file against the grant of succession certificate in favor of the respondent.
That leave was granted.
Not yet.
We'll grant him the leave then.
But Lordship, in the present circumstances, the instant appeal being redundant and infectious, because appeal was filed with leave, but till date the said leave was not yet been given.
In the succession proceeding, they were not naturally not parties.
They are not parties.
How can they be? Because you deny the will itself.
But they appeared, filed an application.
Yes.
but the learned trial judge, upon finding that no vakalatnama was there in respect of the said application, and accordingly the said application was rejected. Lordship, what happened?
Their intervention application was rejected.
Rejected. During the pendency of the instant appeal, the deceased appellant,
They never were implemented in that succession proceeding.
not yet.
Not yet means it has been granted.
It has been granted. They have filed they have filed objections, but on account of certain circumstances, they did not turn up thereafter, and accordingly,
How could they file objection if they were not permitted to intervene? You say their intervention application was rejected.
Rejected.
It was filed under Order 1 Rule 10.
Not. It was most probably preferred under Section 151.
That's very well. That was rejected, but their objection was taken on record.
Yes, but there was a direction passed by the learned trial judge upon the appellant, deceased appellant, to produce the original will, alleged will. But thereafter, they did not turn up, and accordingly, after fixation of 3 or 4 days, the probate the succession application was disposed of.
Disposed of upon put up application filed by my learned friend.
Very good.
My lord, what happened?
So they are alleged that they were given some time to produce the will.
Yes.
Before that period, you made a put up petition and it was disposed of. What is your answer
Yes,
to
that
that?
is the order, my
Please,
lord.
please. What is your answer to that?
Lordship, by filing an application for preponing the said date, learned trial judge preponed the said date from 30th August 2018 to July 13th.
But they were given time previously to file that will within 30th August.
Lordship, the copy of put up application accompanied with the application for prepon of the said date was duly been served upon the learned advocate of the respondent.
Anyway, we are allowing this substitution application and the leave application. We will give our reasons.
Lordship,
We have heard you. We will record your arguments.
Lordship, kindly permitted to file affidavit in opposition.
No wastage of time unnecessarily. We will record your arguments. We will.
Lordship, deceased appellant during the pendency.
What will you prove? I mean, what will you ever in that opposition?
Lordship, this is a file. This appeal filed by one Bhojendra Mandal as executor of an alleged will, but at the same time, during the pendency of the appeal, Bhojendra Mandal, by claiming to be the owner of the schedule mentioned property in the will, disposed of those properties under scheduled properties. Lordship, that's why it is very much required.
Then opposition is required. Yes. Well, if the file opposition to all the applications, what is CAN 5?
CAN 5 is filed by me, seeking an order of stay of the proceedings of the instant appeal.
Of the instant appeal?
Of the instant appeal.
How dare you? Before the same court. Why should we stay our hands in the appeal?
Lordship,
what we'll reject first this application, then start.
Substantial question of law involved in this matter.
Substantial question of law is not required in a first.
How long an executor without obtaining probate?
If question of law is involved, then it has to be heard. Why should we stay our hands? Why should we stay it? What is the ground for stay of the first appeal?
Lordship, because if the adjudication took place of the instant appeal,
then what happened? You lose.
Not at all, but Lordship,
why should the hearing of the appeal be stayed? The grounds you have taken in the application for stay should be adjudicated in the appeal. It should be all the more a reason for hearing the appeal.
But my lord, it has been cited in the said application for stay that without obtaining probate, they cannot proceed with the instant appeal. That's
we'll deal with that. What other application is pending? You are wanting to file opposition to all the applications.
All the applications.
Even to your own application.
Not. Can 1 to 4.
My lord, may I just
wait. Let us. 5 is your application. 3 and 4 are.
Is my application.
4 is leave. 3 is substitution. What are 1 and 2?
1 and 2. That is, I had become
one filed by the deceased appellant for stay.
For stay
of operation of such success certificate
to proceed. Leave to appeal.
But on account of date of the deceased appellant, can 1 and can 2 become redundant?
6 years.
Unless we allow his substitution application. Can 5 you are rejecting right now? we are directing filing of affidavit in opposition against Can 1, Can 3, and Can 4.
3 and 4, they have filed well.
You have filed opposition.
I'm filing today.
Copy has been served upon me.
When?
The
You are
last
prepared with a reply?
No, my.
There was a direction for filing opposition.
No.
There's a direction to file.
Anyway, we are permitting them. We'll take the opposition on record. You file your reply within how much time?
My lord, application 4.
With the oppositions, you will have to file reply. Do you want to file reply?
Yes, sir.
How soon can you do that? You have filed opposition to 3 and 4.
Yes, 3 and 4.
How soon can you file your reply?
4 weeks, my lord.
4 weeks. Very great. The brief facts of the case are that the respondent obtained a succession certificate in respect of the estate of one Siddhartha Ghosh since deceased. Full stop, next para. Although the original appellant herein, late Brojendranath Mondal, claimed to be one of the executors of a will executed by the said late Siddhartha Ghosh, and had filed an application for stay as well as an application for leave to prefer the appeal, Brojendranath Mondal met his demise during pendency of the appeal, due to which Can 3 of 2024 and Can 4 of 2025 has been filed by one Pradeep Kumar, allegedly the other executor of the will, on the plea that the carriage of proceedings survives in him by virtue of the alleged will left by late Siddhartha Ghosh. Full stop, next para. In the succession proceeding, in the succession application, Brojendranath Mondal had sought to imprint himself intervene on the strength of the said will, which has not yet been probated. Full stop. Although the said application was rejected, the application was rejected, the said Brojendranath Mondal, within bracket since deceased, bracket closed, was granted liberty by the succession court to produce the original will of late Siddhartha Ghosh. Full stop. It is alleged by the proposed substituted appellant that before the date of production of the will fixed by the succession court, the said case was taken up by way of a put-up petition being filed by the respondent, and as such was disposed of without the opportunity being granted to Brojendranath Mondal to produce the will. Full stop, next para. Learned counsel appearing for the respondent controverts the very existence of the will and submits that the purported will is a manufactured document. Full stop, that apart, it is argued that under section 213 of the Indian Succession Act 1925, no right as executor can be established in any court of justice unless a court of competent jurisdiction has granted probate of the will under which the right is claimed. Full stop. In the present case, neither has any probate nor any letters of administration been granted in respect of the will, and as such, neither Brojendranath Mondal had any right or locus standi to prefer the appeal, nor does Pradeep Kumar, the other alleged executor of the will, has such right. Full stop, next para. Learned counsel for the respondent seeks to use affidavits in opposition in respect of Can 3 of 2024.
Has already been filed by.
Please. And Can 4 of 2025. Full stop. Such leave is granted and the said affidavits in opposition are kept on record. Full stop. The petitioner in Can 3 of 2024, Sri Pradeep Kumar, is granted is directed to file affidavit in reply, if any, within 4 weeks from date.
It has been filed, my lord. Against Can 3, it has been filed. And 4 opposition just has been served, my lord. So only for 4, Can 4, I have
যেটা
to file.
বললাম, to file reply, affidavit in reply in respect of Can 4 of 2025 within 4 weeks from date, full stop. Reply in respect of Can 3 of 2024, comma, however, comma, is submitted to have already been filed. Full stop. Next para, learned counsel for the respondent also moves Can 5 of 2025, comma, which is an application for stay of all further proceedings in the present appeal. Full stop. The primary grounds on which such application has been filed are that the purported will is a manufactured document and that the original appellant and stroke or the present petitioner Pradeep Kumar do not have any locus standi as executor of the will to prefer the instant appeal in the absence of any probate being granted. Full stop. Next para. However, comma, upon hearing learned counsel for the parties, comma, we are of the opinion that a composite reading of sections 211 and 213 of the Indian Succession Act 1925 clearly indicates that the estate of the deceased cannot be left in the lurch, LURCH. Full stop. Nature abhors vacuum, comma, which principle also applies to the representation of an estate. Full stop. Section 211 within bracket 1 of the 1925 Act clearly provides that the executor or administrator, as the case may be, of a deceased person is his legal representative for all purposes, and all the property of the deceased person vests in him as such. Full stop. Next para. What the applicant in Can 3 of 2024 and Can 4 of 2025 now seeks to do is not to establish his right as an executor, comma, which will duly be done in the pending probate proceeding, but to protect the interest of the deceased in the subject estate of the impugned succession certificate. Full stop. As such, comma, by virtue of section 211 within bracket 1 of the 1925 Act, comma, the applicant Pradeep Kumar, comma, as one of the executants of the purported will, comma, definitely has locus standi to proceed with the appeal. Full stop. Next para. Whether the will is manufactured or not has to be gone into by this court upon considering the evidence on record on such aspect of the matter. Full stop. However, comma, the very fact that such adjudication is to be made in the appeal demands that the appeal is heard and not stayed at this juncture. Full stop. Hence, comma, we do not find any reason or justification for staying our hands in the appeal. Full stop. Accordingly, Can 5 of 2025 is dismissed on contest without any order as to cost. Full stop. Insofar as Can 3 of 2024 and Can 4 of 2025 are concerned, comma, the said applications shall be listed after the timeline given above for filing of reply is exhausted, comma, along with Can 1 of 2025 or 4? 71 to?
1 of 2018.
Okay, along with Can 1 of 2018 within bracket old number, Can 7212 of 2018 and Can 2 of 2018 for passing appropriate orders. Full stop. All the applications shall be listed next on March 17, 2025 under the heading application. We are also listing the application which has become infructuous, the leave application filed by Brojendra, because we have to dismiss that as infructuous. We will do that on the next date. Lock, stock, barrel, entire thing will be heard.
Very good.
এই অপোজিশন গুলো ঢুকে যাবে।
This is my application.
Yes.
My lord, unfortunately, my lord,
though I'm not seeking any relief against the state, but my lord, when service was sought to be effected, Mr. Dawes become a senior advocate now. So, my lord, but my lord, I'll tell your lordship what it is.
Yes.
My lord, it's a land acquisition case. My lord, reference under 18, decree passed, my lord, in my favor. State preferred an appeal. My lord, they were directed to deposit, my lord, a certain amount of money and my lord, disbursement to be made.
Yes.
And the balance, my lord, was directed to be, my lord, invested in a fixed deposit carrying the highest rate of interest, my lord, in, my lord, a bank, and we were to be intimated. Now, my lord, we've written to the Registrar General, my lord, wanting, my lord, that intimation. My lord, the specific direction, I'll show your lordship. My lord, was, my lord, at page 12, if your lordship kindly comes.
This is Can 8.
Can 8. My lord, 19th of October 2020.
Yes.
My lord, kindly come to, my lord, page, my lord, 13.
Yes.
My lord, the paragraph starting in the middle, my lord, further taking admitted leave to be applied in releasing so-and-so, deposited with the appellant as well as will notify the respondent about such deposit. Within 7 days of receiving such deposit, the learned registrar general will make payment of 25% thereof to the respondent and shall invest the balance in a short-term deposit earning the highest rate of interest in a nationalization bank upon intimation.
That 25% was not paid to you.
That's been paid. My lord, the deposit has been made and my lord, there was a modification, my lord, because there was a Supreme Court judgment, my lord, which required 50% to be released. So, my lord, that modification, my lord, order, my lord, is at page 15. So, from 25%, my lord, it became 50%. My lord, the deposit, my lord, was made on 30th April 2021. 31st May 2021, it was released. My lord, the payment required to be released in my favor. But, my lord, where it has been deposited, my lord, we need to know that.
So that the Registrar General has to deposit.
Correct. That's what I said. I'm not really seeking real. My lord, I've got a prayer A2 which is against the state. But, my lord, I'm not pressing that. I need this information. Page 20 is my lord, the letter we've written, which is at page 20.
Very will dispose of the application by directing the registrar. State is not appearing. You have served a copy.
We went, he refused. My lord, I spoke to Mr. Dhar has become a senior advocate now, my lord. Mr. Supratim Dhar.
Oh.
My lord, he was, my lord, appearing in all these matters. And my lord, I don't think, my lord, anybody is willing to work now at the rates, my lord, which are prescribed.
Although no prior service has been effected, we take up Can 8 of 2025 for disposal in view of the innocuous nature of the prayer to which the applicant now restricts itself to. Push up next para, learned senior counsel appearing for the petitioner submits that the petitioner only seeks
A1
relief in terms of small a within bracket small I of the application, that is the details of the bank and the account where the balance amount in terms of the orders of this court dated October 19, 2020, and
my lord, 19th October 2020 and 4th January.
And January 4th, 2021 has been deposited. Push up next para, we find from the said orders that an intimation was to be given regarding the particulars of the investment and deposit by the learned Registrar General of this court to the respondent stroke petitioner. Push up accordingly, we dispose of Can 8 of 2025 by directing the learned Registrar General of this court to intimate the details of the bank account where the balance amount of rupees 18, 23, 74, 004 oblique dash
rate of interest is important.
Has been invested, as well as to intimate to the respondent stroke petitioner as to the rate of interest which such investment is due to fetch.
And my lord, the interest accrued as well. Today the decree is, my lord, 33 crores.
Very well. Further, the learned Registrar General shall also intimate to the respondent petitioner the interest which has already accrued on such deposit till date. Full stop. Such information shall be furnished by the learned Registrar General within 4 weeks from being approached by the respondent petitioner. No arrest to cost. We have disposed of them.
Number 5, I am for the very short ambit of the matter that I objected to grant of a will.
Defect has been removed, sir.
The defect has been removed. There were directions, my lord. And before Justice Prashad, my lord, there was a direction for preparation of, my lord, the compilation of documents so that the appeal can be heard out. Because the appeal is on the point, my lord, that the probate was granted based upon my admission in the cross-examination. I am the daughter. Father executed a registered will in favor of both the sons. In my objection, I said that the will was not properly executed, and all the defenses as against a grant of a letters of administration were taken. In course of cross-examination, I am a rustic lady. I am not much literate. I said that I do not object to grant of probate. That was the only sentence that I spoke about in the cross-examination. Based on which, application under Order 12, Rule 6 was taken out by my learned friend, and that was allowed by the learned judge, granting letters of administration in favor of the beneficiaries. So my only point before your lordship is, whether a court of conscience can grant, letters of administration based upon, a statement in, the cross-examination. When
What
there
are the
is an
pending
objection
applications?
on record.
So we are taking up the appeal. That was the understanding by before Justice
Yes,
Prashad.
we are prepared, that.
But today, my lord, the application is listed, my lord. The application, my lord, orders, interim orders have been passed, my lord. They're enjoying the interim order, my lord. That
You have also
application
filed an application for vacating.
No,
Application
there
for
was a
vacating?
I tell you, lordship, there was an application filed by my client, termed as vacating. It is not a vacating application.
The injunction
It was an injunction application, but nevertheless,
Copy paste.
there is an interim order, passed by this honorable.
What sort of interim order? Injunction?
But injunction, restraining them not to alienate the property in the meantime.
So we can take up the appeal whenever.
But your lordship,
Paper books you can file. You can file the paper books right now.
But the compilation were directed. We had filed the compilation.
You have filed in the department.
In court.
In court, compilation.
Compilation.
Yes.
This is a compilation. You have got copies of this also.
Right.
So we take it up tomorrow. But
Material
take them in next
instruction
week. Any day next week.
Next week. So applications are still pending.
Application and the appeal. If your lordship is with me, then it should go back for a final hearing. Or if your lordship finds that that is a proper admission, then
we find from the records and as submitted by learned senior counsel appearing for the appellants that the previous understanding was that the appeal along with the applications shall be taken up for hearing. So accordingly, a compilation of documents have been prepared and filed by the appellant, and copies thereof has been handed over to the learned advocate for the respondents, containing all the relevant papers. First up, next para. Accordingly, we direct the appeal to be listed along with the applications for hearing on February 17, 2025.
But 17, let it be on 19th. Wednesday. Next Wednesday.
Very well. February 17,
May it be clearly at the top. Otherwise, your lordship had directed it. No, problem hocche to year wise chole jacche.
Yes, it will go year wise. No, not fair.
Small matters, which we are willing to have it disposed of. Another partition should matter.
Taking advantage of this, Mr. Mukherjee, the matters which are not small are also being mentioned as small, and when you take up the matter, we find it. No, you will obviously not do that. You will not do that, but probably you have exhausted the fairly at the top quota.
Then, your lordship might fix up, one day for hearing of the appeals. There are number of appeals.
We'll start with the hearing of the appeals on that day.
The whole day for the appeal here. The majority of your lordship's time are taken by the applications.
Yes.
We are benefited either way, but not for.
No, you're right. The appeals have to be tasked. Somebody has to hear the appeals.
My lord can give preference to appeals one day, my lord, order
that is
41
what-
to one day and applications to one day.
The application order 41 we can handle in a day,
In this court, my lord, one day at least 3 or 4 appeals will be, my lord, over.
provided the appeals are like this.
There are.
And counsel are also like this. No, most of the counsel are very precise. That we must admit. Most of the counsel, they're very precise on the point. So anyways, very well, let it appear on 19th. Let it appear on 19th. Then we'll consider that if you take up. The returnable date of complete column not February 19, 2025. So we have Fridays we sit singly. Wednesdays we take up original set matters in the first half. So no use taking up appeals. So we have to take up appeals either on Monday, Tuesday, or Thursday. Thursday will be a good day, probably. Middle of the week, geared up for hearing of appeals. আচ্ছা কাল থেকে লিস্টে application order 41. Yes.
The appeal is from an order by which the order 7 rule 11 application was allowed.
This is item number 6, right? Yes.
So the plaintiff's first appeal. In connection with the appeal, 2 applications have been taken out, which is CAN 1 and CAN 2. CAN 1 is an application for recording of the death of one of the parties to the appeal.
Respondents.
Yes. And
heirs are on record.
Heirs are on record. The difficulty is there is a mistake on our part. For this respondent number 1, in the suit itself, the recording of death had taken place. So the amended plaint cause title was not followed, and the mistake crept in the memorandum of appeal. The substitution or recording of death only, because the heirs were already on record, the defendant number 1 was already carried out before the trial court. So it's a mistake in the
directive to delete the name.
That is one. But the problem is with regard to the respondent number 6. Respondent number 6, we were under the impression that respondent number 6.
Your applications carry the caption memorandum of appeal from original decree.
It's there,
what else will you copy paste?
No, because it's from the memorandum of appeal, that was
your advice.
No, it was copied from that. I think
because it is from the memorandum of appeal. Why not the cause title of the suit and everything which preceded that?
That was possibly in CAN 1. CAN 2 is correct, CAN
no,
1.
Equally bad. CAN 2 starts with memorandum of appeal from original decree, and then number is CAN 2.
Then that's a...
You should not do this, Mr. Anyway, so CAN 2, what is the problem regarding the other?
Yes,
Respondent 6, what happened to him?
We were under the impression in CAN 1, while we filed CAN 1, that respondent number 6 died issueless. We were unaware of the date of death of respondent number 6. Now, we have come to learn that the respondent number 6 has passed away before the suit was decreed or dismissed. So, and he was survived by heirs. So, we have taken out CAN 2, praying for substitution of the respondent number 6, though the date of death of the respondent number 6 predates the date of the decree. But possibly, we would be covered. This possibly, subject to correction by your lordship, is a situation of order 22 rule 6. If your lordship kindly takes a look at order 22 rule 6, perhaps, subject to correction. No abatement by reason of death after hearing.
Oh, the death was after hearing?
After hearing, before the decree. But we were not aware of the date of death.
But in any event, you have to implement them as parties.
Anyways, we have to.
You had to make an application actually for leave to prefer appeal against them.
Yes,
following
because
order
it's
to
really an addition of party or something of that sort, my lord.
not even
happening
addition of
that
party
way.
or leave to prefer appeal against them because they were parties in the court below. They were not implicated in the court.
They were not implicated in the court.
So leave to prefer appeal because they were not parties in the court below. You had to make an application. We'll treat this application as that.
So, my lord, this
subject to
this
hearing
application has been objected by the respondents on two principal grounds.
So can one goes without demur?
Can one possibly can go so far as respondent one is concerned, only recording of death. That is also, my lord, that had already been carried out before
No
the trial.
difficult on that.
There are some prayers in Can 1 which overlap with Can 2. If your lordship would kindly
Yes.
have Can 1,
Huh.
I cannot come in the way perhaps of Can 1, but not all reliefs which are prayed.
No, no, no,
No,
no.
I am only praying
No,
for
no, only A.
only A.
Only
Yes,
A.
I am also restricting to A.
Only A.
Yes, because others I cannot.
We are allowing Can 1 and then hearing you both on 2. After order, Can 1 of 2024 has been filed for recording the death of respondent number 1, Rajesh Goenka, who had died during pendency of the suit in the court below.
Yes, and this death was already recorded. We filed in the wrong cause.
In the court
Unamended.
below, full stop. Next para. Since the heirs and legal representatives of the said deceased respondent number 1 are already on record, comma, Can 1 of 2024 is allowed, comma, thereby directing the name of respondent number 1, Rajesh Goenka, to be expunged from the records. Full stop. Necessary consequential corrections in the memorandum of appeal shall be carried out by the learned advocate on record for the appellant during the course of the day.
But, may I file the affidavits in reply in my lord?
Opposition you have filed.
Yes, opposition.
They have filed opposition.
Yes, yes. Pleadings are
These are
complete.
the affidavits in reply so far as Can 1 is concerned. And my lord, these are the replies in Can 2.
Oppositions are on record.
Yes. Oppositions on record. Have you filed?
You have filed previously. Checked up.
Yes, my lord.
Very well. Affidavits in reply filed in connection with Can 1 of 2024 and Can 2 of 2024 are also kept on record. Full stop. Can 2 of 2024 is now taken up for hearing. Yes.
The affidavit of service. But Can 2, the facts are that, my lord, the date of the decree is, my lord, 10th of February 2023.
Wait.
And the date of death.
Just let us find out the opposition first, sir. Yes. Yes, sorry.
Well, the 3 dates your lordship will kindly take a note of.
Right. What are the dates?
First is the last date of hearing, which is 7th of September 2022. Then, my lord, is the date of death of the defendant number 6, 23rd of December 2022. And third is, my lord, the date of the decree, which is 10th of December 2023. 10th of February, I'm sorry, 10th of February 2023.
Rejection of plaint then.
Yes, the plaint was rejected.
Very well. Yes.
But possibly, my lord, it would be covered by Order 22 Rule 6 situation.
All right.
But in the affidavit in opposition, but we had pleaded that we did not know of the date of death or that they were survived with any heir. We were under the impression that, my lord, they were not, he died issueless. So, my lord, in Can 1, your lordship will find that we had also prayed for that his death be recorded.
But Can 2 you have not.
Can 2 I have. Now, after coming to know of the legal heirs, I have filed Can 2. Wanting to, my lord, substitute the deceased defendant number 6.
What is their defense?
Their defense mainly twofold. A, we were all along aware of the death because that the death was published in newspaper and the names of the heirs were also there. And 2, my lord, and 2, that in a high court suit, the advocates were common. So in that suit, this death was recorded. So this we should have known. And this is a belated application where there is 700 odd days of delay. So it should be dismissed.
In the High Court suit, what was there to show?
But I do not know. I'm not a party. The plaintiff is not a party to in the High Court suit.
The advocates.
Advocates was common. The advocate representing my advocate. My advocate.
You now present advocate.
My now present advocate.
Represented whom there?
Somebody else in that suit where I'm not a party.
That suit is not between these parties.
Not between these parties. A plaintiff was not a party to the suit.
What was the suit about?
I do not.
They must have pleaded in the opposition.
Your Lordship will kindly take a
How
look
can
at
you
the
say I do
affidavit method once. There's an
You
affidavit.
did not know, but now you know from the affidavit in opposition.
But the plaintiff is not a party to the suit.
What is the suit about? Not the subject property. Your suit, initial suit, the present suit is for declaration of your title.
For declaration of title and also for partition.
Very well.
And
rejected on the ground? Plaint rejected on the ground?
That's no cause of action. No, my lord, if
and what was the other suit for? For the same subject matter?
But other suit, my lord, they have not annexed anything. They have only annexed an order. Kindly takes their affidavit in opposition once, my lord. Page 11 is the order. But by the looks of it, I think possibly it's a probate. Probate and testamentary suit has been, my lord, possibly. If your lordship sees the number. Because it's possibly.
You also claim through Anandi Devi Goenka?
Yes.
So
Anandi.
Anandi Devi. Anandi Devi Goenka.
Yes.
So you claim intestate.
I claim.
Intestate title through her. And this is a probate application apparently.
Yes. So, my lord, page 11 is the order.
Who is your advocate on record?
My lord, present advocate on record, Mr. Raja Balial.
Raja?
Balial. Kindly sees their name is appearing.
Yes.
At the, my lord, third learned advocate appearing at that page. So, by relying on this.
Mirza Saraf is a party here in your suit.
No.
Very well.
But and my lord, that page 12, your lordship will kindly also take a look at. This is also what they had stated. They had annexed rather. That this was served, that the advocate had served on the advocate, that the defendant number 2 had expired. Well, I do not know who the defendant number 2 was from this, but had expired. Enclosed please find here with the death certificate and the name of the legal heirs.
They say defendant number 2, there was this, the present respondent number 6.
Possibly, yes. They say that. But I do not find from either the order or the.
Fox and Moon, Raja Balial is of. You are Raja Bali?
No.
So Raja Balial is of Fox and Moon?
He is of Fox and Moon. But this I do not dispute the fact that he was representing or he is now representing me. That is not an issue, but it was never informed to me. So I do not know that. And I'm not a party to the suit. But, this is my first limb of submission, my lord. And the second thing, your lordship will kindly have a look at my application once. Kindly takes page 3, paragraph 4, where I had pleaded that I was under a bona fide impression that Atmaram Goenka died issueless. So I had taken out Can 1 merely only to record the death, where I have pleaded that he had died issueless in Can 1 also. But then, my lord, we came to learn in December 2024 that he did not die issueless.
How did you come to know?
But from the others, my lord, I came to know. But
you have disclosed nothing. That is very crucial here.
Yes.
That is very crucial. You cannot be vague on that. If you are vague on that, then you could have known earlier. I mean, why? What prompted you to file this application?
But from the.
You have not stated anything.
No, I have not.
Appellant has come to learn.
Yes. And also that I was not aware of the
you
other
have to
legal
disclose where you came to learn that from, because otherwise we cannot ascertain whether you could have learned from that source earlier also.
Yes, I understand. But my lord,
something should have been given. Rumors in the locality, or a bird flew by.
And paragraph 6, my lord, I had stated that I had no relationship with respondent number 6 and was unaware of his legal heirs, because, my lord, just to indicate one thing, my lord, going beyond the pleadings from the plaint, my lord, I just want to indicate one thing. The plaintiff before your lordship is the son from the first wife of his father, with whom there is a divorce, and he was.
Please repeat.
I'm sorry. Lord, may I take out the genealogical table which I had done?
No, just tell us.
Yes.
Plaintiff is the.
Just a second. my lord, the property was Mohanlal and Anandi Devi Agarwal's, Goenka. They had 3 sons, Savarmal, Atmaram, and Chandra Prakash, and 6 daughters. Now, the first son, Savarmal, had 1 son, Rajesh, who is my father, and my mother is Oruna, with whom my father had a divorce. So I ceased to have any relationship with this family, or I did not stay with this family. There was a divorce of my mother.
You are a son of that family.
I am a son, but I did not reside with the family.
You resided with your mother after
I
that?
resided with my mother after the divorce. Now the defendants are the heirs of my lord, are the second wife and son from that wife. So my lord, I did not
have any touch with them.
I did not have any touch with them. So I did not.
This is to establish that you could not have known.
I could not have, but there is nothing, and it fell from your lordship correctly that how I knew. How I came to learn suddenly.
Yes.
But, that is what I indicated in paragraph 5 and 6. And also in the
You had no relationship, nothing. There is nothing to show that you had subsequently your bonds were renewed.
No.
Nothing. You live elsewhere also.
I live elsewhere also.
You live in New Delhi.
Yes.
And they live in Calcutta.
Yes.
How did you come to know? All on a sudden, why couldn't you have known earlier then? No explanation, Mr.
From the other relatives, I have come to learn.
So this is an application for substitution.
For substitution.
After setting aside revenue, non-condemnation. What is the delay?
No, the delays would be, if the date of death is considered, 700 days. But the suit has been decreed in the meantime.
Oh, you say that the other point also remains that whether
possibly there will not be any abatement, possibly subject to your lordship's interpretation in these facts of the provision.
Let us hear them. Yes, Mr. Thakur.
Apart from the scant explanation of delay, hardly anything to talk about. But perhaps there's no case of substitution here. The defendant number 6, Atmaram Goenka, who has died during the pendency of the suit. Lord, he was impleaded, and I don't have the plaint here. Kindly permit me to hand over the plaint. He was impleaded because he was the executor of the will. The executor of the will. An executor of the will has a personal right. There's no case of substitution. The right ends. The executor dies. His heirs cannot get substituted.
Order 20 Rule 10, if there was any other executor, other legatees have to come in there.
No, the legatees can be substituted. The legate, please hand over the.
There was no other executor.
There were 3 executors. He was the last surviving executor, Atmaram Goenka. The will has been granted probate. So the will has already been probated. This was a suit after will has been probated. Now, if you are to allege
in their suit, Atmaram has been impleaded as a defendant.
Correct.
In what capacity? I mean,
as a capacity of executor. Your lordship will kindly see the plaint now, because there cannot be any substitution.
This is the plaint.
Yes. There cannot be any substitution of a deceased executor, because that is a right in person.
Yes,
in the office. So there can't be, his legal heirs cannot be brought in. Kindly see the plaint once, please, my lord. Kindly
assent to legacy has been completed.
Everything done. In any event, my lord, that was an office of the person. Whether done, not done, he as legatee, if he claims to be legatee, he has to take out a letters of administration. Or he can claim.
No, if he impleaded him, that person as an executor, in the capacity of an executor,
yes,
then he could have impleaded under Order 20 Rule 10 the other executor, because if
other executors,
yes,
not the heirs of a deceased executor.
No, definitely not.
Yes, so now he wants to bring in heirs of a deceased executor.
That remains.
So that is the heir. There's no question of substitution in this case. Delay is a second. But I find that this ground is fairly, I must be fair to my learned friend also, since he's not addressed your lordship, he is fairly addressed your lordship on the 2 grounds which are taken in the opposition. The fact that the cause of delay is unexplained and he was always aware. These are the 2 grounds, but this is a pure legal argument, my lord. It is not taken in the opposition, but this is a pure point of law that an heir of an executor cannot be.
Yes, in law, if there is no necessity.
One thing, if your lordship kindly takes a look at paragraph 6, possibly he was impleaded in his individual capacity.
Kindly,
that's why you are looking into the plaint.
Yes, let us see the plaint, please, my lord. And what
Take
is
your seat, Mr. Gupta will come back to you.
Yes. Now, my lord, kindly come to paragraph 6. Yes. Swarnamal Goenka deceased continued initially under his father, as did his other brothers, the defendant number 6. We are concerned with defendant number 6 here. That is the family. So defendant number 6 is his uncle. There's no dispute about that. And Chandra Prakash. Principal business of Mohanlal Goenka, deceased was in coal, etc. etc. So this is, my lord.
But then he has been implicated in his individual
No, my
capacity.
lord, kindly come to what is the subject matter of the suit. Kindly first see the plaint once, please. Kindly see the reliefs. That will be easier to understand what the plaint is. So kindly come to page 14. Declaration that the suit premises situated at.
Can we keep this copy, Mr. Gupta? Plaint.
We do not have any other copy, my lord.
I'll hand over this to my friend after I'm done.
No, you.
For your lordship's
We
reference.
can only return the back sheet to you and nothing else. Back sheet of everything.
Custodial legis হয়ে গেছে।
না ব্যাকশিটে পুরো নোট করা আছে
হ্যাঁ ব্যাকশিট নোটটা নিয়ে নিন। এই নোটটা মোর ইম্পর্টেন্ট ওই নোট থেকে এই নোট
Take it up, we'll keep. Oh, you don't have any other copy.
No, no, this back sheet is all that is important. Rest your lordship can keep.
but we have it scanned, I'm told, so we'll
No, very well, we'll take it later. Then let us go through, because we can't mark it. The difficulty is there. You don't have a copy of the plaint.
I'm getting copies, man. Your lordship will keep this. I'll give my learned friend for the purpose of arguments. I'll hand over my copy to my learned friend.
Yes.
Kindly come to page 14, please, my lord.
একটাই তো কপি আবার দাঁড়ান দাঁড়ান Pardon me. Just Yes. Declaration that the suit. Yes.
Declaration that the suit premises situated at 27 Baliganj Park, Calcutta, so-and-so, is joint family property of Savarmal.
Partition suit, clear.
Yes. So suit property, there's a partition suit in respect of this property. Now,
he has been described as one of the owners.
No, my lord, he's not described as one of. Kindly come to, my lord.
Yes.
Kindly come to paragraph 9. Yes. Kindly come to paragraph 9 now, please, my lord. In or around 21st February 1972, Kamal Kumari Law demised on lease premises number 27 Baliganj Park, suit premises so-and-so, written to Anandi Devi for a period of 70 years on rent. Terms continued. Therefore, the demise of by Kumari Kumar Law in favor of Anandi Devi was operated till 2047.
So this plaint was rejected for non-disclosure of cause of action.
Yes. Because, my lord,
Rightly so. Rightly so.
it's really partly throwing in the dark, partly that, because he was not there, so my lord,
Yes.
Lordship will read further. So this was a leasehold property of the deceased Anandi Devi.
Yes.
Now, my lord, deed of lease was subsequently rectified. Deed of now kindly. After the 6 deeds of Mohanlal Goenka, deceased were married. It was Savarmal, defendant number 6, and Chandra Prakash, who used to reside at the suit premises. Then kindly read further. Bihar Cotton Mills, so-and-so, Anandi Devi required Savarmal to ensure tenants would vacate, tenants vacated, etc., etc. Then Savarmal managed to secure vacant possession, paragraph 14. Then the entire property, my lord, was obtained from the tenants. Now kindly come to.
No, what is the relation of defendant of 6 with the others? I mean,
that I'll show you, lordship.
That has not been stated here also.
Yes, nothing. Now kindly see 17.
17, yes.
Yes. Late Anandi, so this was a leasehold right of Anandi Devi. Anandi Devi Goenka died on such and such date. It appears from the records of diverse court proceedings that Anandi Devi Goenka deceased died tested, leaving behind a will and testament dated so-and-so, copies annexed. Said will, this is the will I was telling you, lordship. The said will was probated by learned 10th additional judge at Alipur by order dated so-and-so. The will was granted probate. And D6 was one of the executors of that will. By a will dated so-and-so, Anandi Devi had appointed Mohanlal Goenka, deceased, already deceased, defendant number 6, and Dayanath Maskara as the executors. The executors were directed to administer the estate of late Anandi Devi, which would ultimately vest in other beneficiaries. Dayanath died on 16 September. So this defendant number 6 was the sole surviving executor. Now, my lord, kindly read further. In accordance with the wishes of Anandi Devi, her estate formally created demise in respect of the suit premises in favor of
There is no other capacity of defendant number 6 actually disclosed in the plaint. We don't find it subject to what we say.
It's only as in capacity as executor. And that is why now, it is at estate of the deceased, the probate has been granted. That is why the suit was rejected as not disclosing a cause of action. And thereafter, my lord, Rajesh Goenka, the defendant number 1, bought out the suit property from the laws.
So who are the legatees of the will?
Legatees of the will is Rajesh Goenka. Kindly see the will which is there. Probate has been granted. See. is at page.
They state that in the plaint also.
Yes, they state that. That is also there. Kindly come to defendant number. He says defendant number 2 is claiming to be the sole owner of the suit premise.
Where is
Defendant,
that paragraph?
kindly come to paragraph 24 at page 8. Now kindly see paragraphs A and C of the particulars of fraud. My mother had a leasehold interest. That is defendant number 1's mother, who has since passed away. The order which your lordship made just now.
Who is Anandi Devi? Anandi Devi is the grandmother.
Anandi Devi was the grandmother.
All right.
Now Anandi Devi's son, defendant number 2, who is my lord Rajesh Goenka.
As per the will annexed by them,
Yes.
Rajesh got the entire property.
Yeah, my lord, it's Anandi Devi could have only bequeathed her leasehold, right?
Yes.
Kindly see the particulars of after Anandi Devi's demise. Rajesh, this property, my lord, was left to the executors to bequeath to deal with in accordance with law. That was an absolute bequest on the executor to deal with as they deem appropriate. After the demise of Anandi, Rajesh bought out the head owner's interest. That is the owner was bought out. Kindly see a deed of conveyance. Kindly see the particulars of fraud at C. A deed of conveyance dated so and so has been executed by Ashish Kumar Law in favor of D2. So, my lord,
who is Ashish Kumar Law?
The owner, original owner, Kamal Kumar Laws. Kamal once.
Oh, who granted the lease to Anandi?
Yes. So Rajesh Goenka bought out the ownership itself.
They have challenged that deed also.
Kindly see, my lord. Deed of conveyance is
annexed. The release, we saw the release.
Yes, your lordship saw the relief. That deed is not challenged. That deed is not challenged. Declaration that he continues to be tenant.
This comes under the NDPS Act, Mr.
So, my lord, executor cannot deceive.
Absolutely.
The main appeal I haven't needed.
They main appeal I am not, but this substitution cannot happen.
Kindly,
I am a Supreme Court to show you.
Not only Excise Act, this is just NDPS, pure NDPS.
No, my lord, now PMLA is the flavor of the season.
No,
Money
you
laundering.
have missed out.
Oh, I see. Oh, yes. Yeah.
More than that, must be something more exotic.
More sophisticated.
Ayahuasca or something.
More exotic.
But what have you done?
I do not know, my lord. I've been only briefed in the appeal, my lord. I do not know.
So in any event, the application has to be rejected then.
D2, my lord, as far as D6 is concerned, my lord, there's one.
We will dispose of the application by directing the name of this person to be deleted.
Yes.
Only deletion. It cannot be an abatement.
No, there is no scope of substitution. That is what we say.
Grateful. There's no scope of substitution.
But
it's a bit different. No question of abatement is different from no scope of substitution.
There's no scope of substitution.
But show us something from your. This is the only copy.
No, I'll hand over one, my lord. This was a point which was not taken.
There was a point.
Show us something, Mr. Gupta, to at least satisfy us that he was implicated in personal capacity or something like that.
But there were allegations of fraud against him. But to be honest, my lord, I've read all the paragraphs now as Mr. Thakur was. It was fraud in the capacity as an executor.
An executor.
But and also that illegal surrender is also there. So, my lord, he has been pleaded. Possibly, my lord, if I can stretch it in both his capacity also, but your lordship will see the plaint, my lord, and then.
There is nothing in the plaint to show anything, any allegation. I mean, any reference to him in personal capacity.
But then could I, my lord, humbly suggest one thing subject to what falls my lordship?
Fix the appeal for hearing and dismiss it soon.
Yes, kindly fix the appeal for hearing.
This is one of the appeals, as Mr. Mukherjee said, which
short matter.
Short matter. This is actually.
But kindly.
Who is your leader? Depends on that. No, it will be short then.
So, my lord, he is briefed in the appeal, but the cans, my lord, I was.
Have you had a conference with him?
No.
He was briefed in the can also. He appeared.
So you may have to appear yourself at the hearing. Be prepared for that after the conference.
Can one, your lordship is allowed?
Can one we have allowed? Can two we are rejecting on this ground?
On the ground of substitution.
Kindly does not reject. Kindly keeps the can.
You show us anything from the plaint to show that he was implicated in personal capacity.
I did not know that they would be taking this, but I'll try and satisfy lordship if I can get anything. Otherwise, I'll not.
After so much hearing, sir.
But
go through your plaint now.
Yes.
It's a rather longish plaint. And Judge chapter diye chera. Tomar jonne.
Na,
tomar
one with Justice Kumar. But if your lordship kindly.
That copy which I've handed me is Justice, my lord, Justice Kumar's copy is marked. I'm sorry for.
But if your lordship kindly takes.
My copy is also marked. It's not difficult on that.
But kindly comes to page 3 of the plaint, my lord, paragraph 6.
Again, paragraph 6. Yes, what is there?
And paragraph 6,
precious.
my lord, Samarmal Goenka continued initially under his father as did his brothers, the defendant number 6 and such and such. Then kindly comes to paragraph 11.
Continued what?
Continue to occupy.
Position, exactly.
Position,
In another
yes.
paragraph also you have stated position.
Yes. Now paragraph 11, yes.
He used to reside.
Reside at the said premises. Then, my lord, paragraph 13, defendant number 6, along with the other families, left the residence. That is paragraph 13.
Very good.
Now, my lord, paragraph 16 is also where I had stated that the defendant number 6 had shifted elsewhere.
Yes, but nothing to say that they are co-sharers or anything about.
No, on the contrary, we have not said him as a co-sharer.
You have not said he was a co-sharer, and you have said he was an executor.
Yes, I have not said that portion. I should place directly now, my lord, page 11, paragraph 30. There's a table where I've indicated who all have the shares, and defendant number 6 is not there.
Yes.
Is not there.
We will reject the application right now. Learned counsel for the petitioner submits that can 2 of 2020.
Only one thing. If your lordship kindly sees the particulars of fraud and paragraph 33 and kindly decides.
We are not saying he's a. As the particulars of fraud.
Yes, particulars of fraud and paragraph 33. If those are of any relevance, my lord, if your lordship kindly considers paragraph, my lord, 24.
No, we are not on that. Not on that. Whatever, I mean, we are not saying that he was not a necessary party in the suit.
But your lordship is saying because he was.
We are saying he might have been a necessary party because there are allegations against him. Even whether he was a necessary party, we have our doubts.
Yes, of an executor cannot.
At best, I mean, if some third person, I mean, if I file a partition suit, it shall only be against my co-sharers. If a third person committed a fraud in whatever capacity, he is not a necessary party to the suit. Anyway, we are not holding that, but we are saying that.
But only kindly only says paragraph 24D and paragraph 33. Those are the only two paragraphs.
Allegations of fraud.
Yes, that is one. Paragraph 24D.
Executor too.
Yes.
Only as
I'm only showing these two. There. Nothing else is there. Paragraph 33. Those are the only things. 33 and 35. Otherwise, nothing is there.
কোথায় ছাড়লাম একদম has been filed for substitution of the heirs and legal representatives of deceased defendant stroke respondent number 6, namely Atma Ram Goenka. Who's up next para? It is contended that the rigors of abatement are not applicable since the last date on which the learned trial judge heard the matter was September 7, 2022, whereas the defendant number 6 died, although during pendency of the suit, after the last date of hearing, on December 23, 2022. Full stop. Ultimately, the plaint was rejected by the impugned judgment and deemed decree on February 10, 2023. Full stop. Hence, it is argued that the provisions of Order 22, Rule 6 of the Code of Civil Procedure are applicable and the suit could not have been deemed to stand abated. Full stop. Next para. It is contended that initially the appellant, who lives separately from the deceased defendant respondent number 6, was not aware of his demise and or about the heirs and legal representatives of the said deceased. Full stop. Upon coming to know, at the earliest thereafter, the present application has been filed. Full stop. Next para. Learned senior counsel appearing for the. You are appearing for 1.
2 and 3, my lord.
2 and 3. Learned senior counsel appearing for respondent numbers. Yes, 2 and 3. Opposition by them only. Respondent numbers 2 and 3 contends that the scope that there is no scope of substitution of the heirs and legal representatives of the deceased respondent number 6 in his personal capacity, since the said respondent was impleaded in the suit apparently in the capacity of an executor of a will, comma, the probate of which has since been granted. To sub next para, learned senior counsel takes the court through several averments made in the plaint, from which it is evident that the plaintiff stroke appellant averred that the deceased respondent number 6 was the executor of a will. Push up, although certain allegations of alleged fraud being practiced have been leveled against the deceased respondent number 6, and it has been stated in the plaint in certain paragraphs that the deceased respondent was at one point of time in possession of the suit property, comma, we do not find that the deceased respondent number 6 had been impleaded in his personal capacity. Pushed up, irrespective of allegations of fraud, comma, fact remains that the name of the deceased respondent number 6 does not find place in a chart depicting the co-sharers, comma, which is a part of the plaint in paragraph number 30 thereof, comma, is not included in the said chart. Push up next para. Moreover, comma, irrespective of allegations of fraud or otherwise, comma, in a partition suit, comma, only the co-owners are the necessary parties. Pushed up, the plaintiff appellant, comma, apart from not pleading that the deceased respondent number 6 was a co-owner, comma, specifically averred in several places of the plaint that the respondent number 6 was an executor of a will. Push up next para, hence, comma, we find substance in the contention of the respondent numbers 2 and 3 to the effect that the provisions of substitution do not apply, comma, since the deceased respondent number 6 was not impleaded in his personal capacity at all. Push up, accordingly, Can 2 of 2024 is dismissed as redundant without an order as to costs. Push up, the appeal is otherwise ready for hearing. Only the plaint is required. Plaint, order 7 rule 11 and objection.
Kindly gives us leave to use a compilation and we shall
do it within a fortnight. In view of another, you have to serve the other respondents. What about service on the other respondents?
Other? Oh, not all. Oh, we are only 2 and 3. I'm sorry.
You are only 2 and 3.
all have been served. We filed the affidavit of service.
In the application, all have been served.
Yes, we shall
But then
serve. The notice of appeal.
notice of appeal, you have
Notice
to
of
serve.
appeal.
Then it will take time. The appellant shall deposit the requisites for service of notice of appeal on the non-appearing respondent numbers 1, comma.
One is dead.
One is dead. Oh, one is respondent numbers 4 and 5 within a week from date, pushed up in view of the short compass of the appeal, comma. The trial court records need not be called for, pushed up. Service of notice on the respondent numbers 2 and 3 is dispensed with in view of the appearance of the said respondents to their advocate. Push up next para. The appellant shall prepare informal paper books without comparing with the records by incorporating the relevant documents within a fortnight from date and serve within 3 weeks from date and serve a copy thereof, serve copies thereof on the respondents. Full stop next para. Upon the service of copies is complete, the service of such copy as well as service of notice of the appeal is complete, comma, the office shall furnish a report to the effect as to whether the appeal is otherwise ready for hearing. Full stop. Liberty to the parties to mention the appeal for inclusion in the list upon such report being furnished by the office.
Grateful. Maybe take back our
Yes.
claims.
Okay. Give a copy to them also.
They have this.
The plaint, no, we have referred to the plaint. You have to keep a copy.
Hey, Lordship will keep our backsheet.
তাহলে ওটা ফেরত ওদেরটা তাহলে ফেরত দিয়ে দিতে হবে।
আমারটা তোমাকে দিলাম তো।
না, আমাকে কিছু দাও না, আমি বললাম তোমার সফট কপি আছে।
Both of you now have torn back sheets.
But in the affidavits, they have got us to bark on a wrong tree, and thereafter.
But you don't have any case at all. Just due to non-service on the respondents, you are saved. Nothing disclosed.
The appeal is not yet ready.
That is why. Otherwise, we would have directed you to file it within a week and taken up the appeal.
We'll try and persuade your lordship. Could not have been done in a 7-11. Great.
Yes. Who is appearing in this? 7? Yes. What is the matter, please?
Fortunately, this is a change brief, my lord, received from the legal aid, my lord.
Fortunately for you.
Documents had already not been received.
This is from legal aid.
Right, my lord.
Legal aid.
Kindly allow me.
You don't have copies of the your applications.
Copy and all the instruction has not yet received from the client, my lord.
Very
Kindly allow me a week's time, my lord, at least.
1 week's time.
At least, my lord.
On the prayer of learned counsel for the appellant who is appearing on change and is not equipped properly with the papers, comma, let the matter stand adjourned till February 24th, 2025. We are giving you 2 weeks time.
February?
24th. Next.
My lord, one thing more. The earlier advocate on record whose name is there, my lord. Yes,
You have to file a no objection.
my lord, I will file on the next date my vokalat nawa.
Leave is also granted to the learned advocate having now instruction to appear for the appellant to file his no objection vokalatnama before the next returnable date.
In that case, the name will be changed, my lord.
ওনার নামটা যখন রেকর্ড করবেন give your name please. ওনার নামটা দেবেন having instruction, advocate having instruction to appear for the appellant. You give your name, only your name. Got it.
I'm appearing on behalf of the appellant. As per direction of your lordship, my lord, I have forwarded all the copies of the application upon the learned advocate, my lord.
Condonation of delay first.
Yes, my lord.
This appeal arises out of what, Ms. Gupta?
Application for grant of probate was filed, one by the appellant and the other by the respondent, my lord.
Yours refused, they are granted.
Yes, my lord.
Okay.
Now, my lord, there is a.
What is the delay?
32 days, my lord. 32 days.
Seriously opposed?
No, I'm not opposing, but there is some bit, my lord, confusion. Lord, she said, my lord, 30 days, once said 130 days. So it is required to be, my lord, I do not know the office report.
Oh.
Calculating the date
14
of
days.
the statutory period and the.
Because she in her.
You have probably included the limitation period also, or what?
Her application, she has.
Paragraph 16, my lord.
Let us see the office report. দেখে নিবি তো 20th December first. This is from which not 20th December ধরুন হলো জাজমেন্টে 11 দিন ওখানে গেল 11
On my lord.
We'll check up. 5th of April. Very well. তাহলে 20 দিন ওখানে গেল $28 days in February 24 last year. 28 or 29? 28.
29.
29. Right. তাহলে 21 দিন গেল 9 30 February 50 হলো 50 আর it is মার্চে 30 No, 14 days. Delays of 14 days.
There must be a report, office report.
That says 14 days, but we have had bitter experiences with the office report. That's why we can. So it's 14 days. For the office report is right. We have explained for 32 days, including the limitation period also.
30 and 30. Both are beaten.
Pardon?
130 and 32 both are beaten. That is the
Statutory
bit of
period also, my lord.
130.
In prayer, your lordship reviews.
Prayer is 32.
130 is also there.
Taking
Yes,
note of
yes.
the statutory period,
30 days.
That is the whole.
What is the reason for the delay?
my lord, after obtaining the certified copy, when my lord consulted, he came to know that 2 appeals need to be prepared, and thereafter he came to the.
You have been briefed from the legal aid services. That is sufficient now. We find sufficient. Legal aid matter. although the period of delay as mentioned in the application for condonation of delay is more than the actual delay of 14 days, comma, we construe the explanation furnished in the application sufficient for the purpose of condonation of delay. Full stop. Next pair, accordingly, can 1 of 2024 is allowed upon hearing learned counsel for the parties, comma, thereby condoning the delay in preferring FAT 108 of 2024. Full stop. The said appeal is deemed to stand registered and admitted. What is the other application? Injunction.
Yes, my lord.
Yes, Mr. Bonik, you want to?
I have some serious objection because so many documents are there. If
We will direct you to file affidavit in operation, but we'll grant injunction in the meantime.
Let it be status quo because my allegation
Does not mean anything. Status quo, tomorrow you will come up with a.
he is in possession. I am also in possession, but he is disposing of some articles from the property. There is a
You have not asked for any injunction.
No,
he has asked.
That is why I have some documents which I need to show your lot.
Show your documents, but you cannot dispose of the property or disturb their possession in the.
No, I am not disturbing, my lord. I am also in possession. Their
My
contention
lord,
was
they
initially.
are not in possession, my lord. From the service, your lordship came to on the last occasion I have submitted that they are not residing in that premises, my lord. That's why another address.
Your
has
lordship
been
kindly
served,
sees the envelope. I received the copy from the suit property. The affidavit service must be there. Your lordship kindly sees, my lord. I have the envelope with me. The receipt envelope.
Since a prima facie case has been made out for hearing the appeal on merits, comma, the respondent is restrained by an order of injunction from disturbing the peaceful possession of the petitioner from the portion in occupation of the petitioner in respect of the suit property and or from creating any third party interest over the suit property during pendency of the application. Full stop. The respondent shall file his affidavit in opposition to the injunction application within
2 weeks.
Within a fortnight from date, reply if any shall be filed.
Lord, injunction must be a specific time, Lord, because since your lordship directed me to file
Applications appear whenever
that
no.
has become
Within a fortnight from date, reply if any shall be filed within March 6, 2025. The application shall be listed for hearing on March 10, 2025. Application will appear on the returnable date. We'll dispose of the application.
Lord, but application, the injunction order seems not has
Till disposal of the application.
No specific direction was there, Lord. Till disposal of the application. Great. Answer. I did not heard that.
My lord, connecting application. FAT 9, my lord.
Also delay there.
The same
Please delay.
2 appeals.
And another is for application
Same
for
ground.
stay of operation, my lord, of the.
আচ্ছা ক্যান আগেরটা যেটা হলো সেটা ক্যান অন্য অ্যাপিলটা সেটা হচ্ছে ক্যান 108 এর হলো ওটা ইয়েস থ্যাংক ইউ এবার ক্যান 1 ইন রেসপেক্ট অফ এফএটি 109 ওই কপি পেস্ট হয়ে যাবে সেকশন 5 এর যেটা আছে এই ক্ষেত্রে শুধু ক্যানটা ক্যানও এক নাম্বার আর এফএটি নাম্বারটা শুধু আলাদা হবে এফএটি 109 অফ 2024 রেজিস্টার্ড আন্ডার আচ্ছা ক্যান 2 অফ 2024 ইন এফএটি 109 টা নিচে স্টে উই ওন্ট রান Stay of what? Probate?
Operation of the impugned order, my lord.
No. Operation with it's a judgment in rem. We won't grant stay, but we have granted injunction. We'll reject your application by giving reasons. Can 2 of 2024 is an application for stay of operation of the impugned judgment and degree, whereby probate has been granted in respect of a will in favor of the respondent, whereas the application for probate of the appellant stroke petitioner in respect of a different will has been refused. Full stop. Since a judgment in a testamentary proceeding operates as a judgment in rem, comma, we are of the opinion that grant of stay at this stage would not be prudent. Full stop. In any event, comma, in view of the earlier injunction order passed in connection with the connected appeal, comma, that is FAT 108 of 2024, comma, we do not find any reason to grant further stay of operation of the decree. Full stop. Next para. Accordingly, Can 2 of 2024 is dismissed in the light of the above observation.
Grateful.
What is the defect? This delay? Yes, out of 10. 10th March, it will be returnable.